Bonjour à tous et à
Good afternoon, everyone. Thank you for being here at this meeting, the 44th meeting of our House of Commons Standing Committee on Public Safety and National Security. As you know, we are meeting thanks to the order from the House of Commons from April 20th, 2026, which was adopted as part of our study on Bill C-22, the Legal Access Act. Welcome once again to our distinguished witnesses. As I mentioned last time, we have started to really get to know them, and you have also started to really get to know us from the Canadian Information Security Service. We have Juanita M., we have Kimberly Gibney, and Norman Wong from Public Safety Canada. And we have Richard Bilodeau, Shannon Eagle, and Fenton Ho. And from the Royal Canadian Mounted Police, Superintendent Richard Burchell and Aaron Galgs. So, ladies and gentlemen, thank you once again for being with us. Of course, we still have much work to do today. So I will do as I have been doing recently. I will invite all MPs to be as efficient as possible in their questioning. I have carried out calculations supported by calculations by the clerk, and we have reached the conclusion that we have to date spent a total of 26 hours and 52 minutes reviewing Bill C-22. And for clause-by-clause consideration, we have spent 10 hours and 30 minutes. We have only covered 7 amendments in that 10 hours and 30 minutes. We would need another 260 hours if we continue at the same pace to complete clause-by-clause consideration, which would bring us to the end of 2028. It is very unlikely that we would be able to continue studying this bill until the end of 2028. Therefore, I would ask all MPs to be efficient and disciplined in our deliberations so we may proceed as quickly and efficiently as possible. With that said, the last time that we concluded our meeting, we completed our vote on BQ4, the amendment BQ4. We are therefore at CBC 3, or rather we finished CBC amendment and we are now at BQ5. Ms. de Bellefeuille, would you like to move your amendment? Certainly, Mr. Chair. First of all, I appreciate your comments, but I found you a bit harsh when you said that we would only end our debates at the end of 2028. We have true collaboration. If we had a true collaboration between all parties, I think it would have been possible to conclude our work in fewer hours. But it's also an issue when the government doesn't necessarily want to hear our arguments or our amendments. So I didn't, as a member of the official opposition, fully appreciate your tone in those comments. Now, regarding Amendment BQ5, this is from the Quebec Bar, and you will understand that for me, the Quebec Bar is an important and credible witness. Amendment BQ5 follows up on one of their recommendations. So production orders regarding subscriber information would have to go through reasonable grounds to believe. And the argument for this wording, reasonable grounds to suspect rather than believe, I was in agreement regarding that with the government, but I think it would be more reasonable for the amendment to be adopted, and that would change the threshold for the data. Mr. Chair, I would like explanations. In this clause, could you explain what would prevent police officers, what would hold police officers back if we changed this threshold for data by using the word believe instead of suspect when it comes to production orders? Because we would be going from one level to another of intelligence and data. And if my amendment were to be adopted, would that be the end of the world for police work? One of our witnesses here is so effective in explaining things and describing things to us. Could you tell me if this recommendation by the Quebec Bar is good?
Merci de votre question.
Thank you for your question. Through you, Mr. Chair.
La meilleure façon.
I think the best way to explain it is this. Usually, we're at the very beginning of an investigation when we submit this kind of request. Then we receive data later in the investigation, and we would use a general production order to ask for the content of files, for example, or other data held by the company itself. But at the very beginning of the investigation, we try to identify links between any type of statement or an account and activity. Normally, there's a period of time where, inaudible for the interpreter, where we try to prove that the person is not guilty. We try to eliminate them as a suspect, rather. So we can carry out different verifications, and then we may discover that this individual was involved with another individual. And sometimes it's possible for us to exclude the individual in question as a suspect and remove them from our list. Ms. de Bellefeuille, here's the question I have in mind. When you gave me the same explanation to say to me that all you want to know is whether or not the subscriber receives a service or not, we need reasonable grounds to suspect because we're at the beginning of the investigation and we need to be able to continue investigating. But now you're coming back to me with the same rationale for production orders as my question before. And you're saying that production orders don't come into play until later into the investigation. And I agreed with you with your first argument when I asked you this question in the past, but now we're talking about a different tool in your investigation toolbox, and I'm wondering if you're going a bit too far. Do you only need reasonable grounds to suspect? Because you're repeating the same arguments for me again. I'm very interested in understanding this further. Thank you for your question. So when it comes to confirming whether there was a service or not, first of all, you have to identify who the service provider is in order to have a search warrant or to be able to apply to divulge further information. That is a threshold we must meet in order to use a regular production order. Now, when we confirm service, what we're doing is we're confirming that this telecommunication service provider is providing this service to this number. But we still don't know who the client is behind that number. And we also don't know if there are other services that are being provided to the same person by the same company. Usually, we use basic information in order to identify the individual, to either confirm that someone could be a suspect or to confirm, to the contrary, that that is not the individual who had been involved with the account in question. We interact with the service provider company and we submit an application because of our suspicions around the client. So these are suspicions. Yes. And afterwards, we will apply to have the information regarding the client. And at that point, we may be able to confirm that this is an individual who has made a statement or a complaint, or it could be a completely different individual. And if so, then we will go down another avenue in our investigation. It may not be the correct individual. Ms. de Bellefeuille, so if I'm understanding correctly, you want to keep the lowest possible threshold right up until you have the right name for the right individual and you have confirmed that you're after the right individual because you want to associate the individual with the phone number. Because first of all, for example, if you call me and you ask the service provider, is Ms. de Bellefeuille your client? Yes or no? Yes. At that point, you know my phone number, but you might not know my name. So you continue your investigations. But it seems to me that at that stage, you have quite a good idea. So could you continue with just a reasonable ground to believe in your investigations? It's important for you to go to the end of your investigations. So is it important for you to have reasonable grounds to believe? That's what you currently have. So you want to reduce it to suspect? Yes, we want to reduce the threshold. How can I explain this? The information available would also be reduced along with the threshold. And when we have a production order, that is signed by a judge or justice of the peace. So this would be a third party who would check to see whether or not our application meets the lowest threshold. But how could, when it comes to a low threshold, it seems to me that it's so low that it's almost impossible not to meet it. Well, it depends on the information we're asking for, and it has to be directly linked to the information that we have asked for prior to that. Earlier, I was talking about what happens at the beginning of an investigation. We might have a complaint where just one individual has made has claimed that something has happened. We can't just say, oh, I believe it's true, because no, we have to carry out investigations and do checks to confirm that such and such an individual is a client with such and such a service provider. And after that point, we can confirm that that individual is associated with this account, and then we can have reasonable grounds to suspect that this person is potentially involved in the investigation. Ms. de Bellefeuille, and then you would have access to the data, because I don't see any reasons why you would be refused. Because at the current time, you need to have reasonable grounds to believe in order to continue to the next stage of your investigation, and you wish to reduce the threshold to have greater ease in accessing data to carry out your investigations further. In my mind, it seems like lawyers against police officers, because all the lawyers, the Canadian Bar, the Quebec Bar, among others, are saying that it would be going down the wrong track. I believe that you are an honest person, an honest police officer, and you have been very honest, but we know that it's possible for corruption to happen. We know that infiltrations can happen. So we have to ask ourselves questions. If Canadian lawyers and Quebec lawyers are not recommending this change in the threshold, that means that your recommendation and your description that you're giving to me now does not persuade me. I don't want to withdraw my amendment. If you were able to convince me that my amendment isn't a good one, then I would withdraw it. but your arguments are not convincing me. So if you have more, I would encourage you to share them with me, because as we are currently, I am not persuaded that you do require such a low threshold. So would you like to give me further examples?
Oui, je pourrais vous en...
Yes, perhaps I could give you further examples. I could explain to you. We're trying to build a file in order to be able to found our accusations. So at the very beginning of our investigation, the data needs to be corroborated. And afterwards, that will be able to lead us to charges. First of all, we have to associate the account with a device and then with an individual. We have to verify that that individual was also the person who was behind the keyboard and was responsible for the crime in question. So, at the very beginning of the investigation, we're talking about information that we're going to have to corroborate later on with supporting information, which we will need to acquire thanks to other warrants or interviews or requests for the data. Ms. de Bellefeuille, so I don't want to be accused of filibustering. So could you clarify, at the current time, I know that there are investigations where you do succeed in determining who is guilty, but it's as if you're telling me now that with the tools that you have, you're not succeeding in finding the bad guys. But I know that you do succeed in many cases, and I believe in your expertise and your competency. But in your testimony, it's as if you're trying to convince me that it's a question of life or death. You're telling me, Ms. de Bellefeuille, we're doing good work, and we are still able to prosecute criminals with a higher threshold, but it would be easier if the threshold were lower. But in my view, that's not necessarily a sound argument, because in my mind, there's a fine line that needs to be balanced between prosecuting crime and protecting Canadians' privacy. So this change in threshold, to my mind, is not necessary because you're already performing well. I don't want to belabor the point, but I'm still cynical. So perhaps my colleagues will ask questions that will change my view. And I'm not insinuating that you didn't answer my questions well enough. I just want to affirm that I am still not convinced. And it seems to me that at present, you're already able to carry out your work as needed to continue your investigations. Thank you, Mr. Chair. Thank you for that excellent exchange. Ms. de Bellefeuille, we have Ms. Cody, Mr. Ramsey, and Mr. Dalton, beginning with Ms. Cody.
Thank you, through you, Chair. I really appreciate this time to ask some questions so I'm a little bit more informed. I'm kind of new here with the bill, and with my systems background, I'm going to have a lot of questions based on IT and such. Bill C-22 contains two distinct parts. The second part, the Supporting Authorized Access to Information Act, or SAAIA, is where the broad interception obligations, the ministerial powers, and the electronic service provider requirements all live. When we talk about the risk in this bill, we are largely talking about SAAIA. Is that a fair characterization of where the most significant new authorities in this legislation are found?
I think both Part 1 and Part 2 are equally important to the lawful access regime. Obviously, it's from a technical nature and complexity nature. Part 2 is probably a little bit more complex and technical, but I would say that both parts operate together to help give law enforcement the capabilities they need or the tools that they, not the tools, the ability to gather information that they need to advance investigations.
Okay, so the government has repeatedly assured Canadians that this bill will not create systemic vulnerabilities. That assurance is
Point
carrying a
d'ordre,
lot.
Monsieur le Président.
Point of order,
Nouveau, on voit que les
Point of order, Mr. Chair. Mr. Ramsey, once again, we see that Conservatives are talking about the very objective of the bill, but we're talking about line 27 on page 7, and it is sub-amendment BQ5. I understand that Ms. Cody wants further explanations, but she should have come to the committee when we were already covering that work, which we have been doing for numerous weeks. Thank you, Mr. Ramsey. Well noted. Mr. Caputo.
With all due respect, Mr. Chair, I don't think it's well noted. We are parliamentarians and we get to come here and we get to ask questions. And I will not allow anybody to get in the way of anybody asking a question, whether it be a Liberal member who has privilege, a Conservative member. If Ms. Cody wants to ask a question about the bill and about the general nature of the bill and how the general nature of the bill impacts line 27 or whatever it was, she has the right to do so. The fact someone doesn't like it is irrelevant.
Il y a effectivement une grande latitude aux questions qui peuvent être posées.
It's true that there is great latitude surrounding questions that can be asked, and Mr. Caputo's comment is well noted. Mr. Ramsey's comment is also duly noted in the sense that it is preferable to ask questions which are relevant to what is being discussed, and we are currently on BQ5. Ms. Cody.
So I can go ahead then? Thank you, Chair. So I want to know about the assurance that carries a lot of weight here so that we can fairly look at anything else this bill claims to do, because it would really help to know what the term actually means in law. Does mandating interception capability inside an encrypted system fall inside that definition or outside of it?
Sorry, can you repeat that question?
Okay, I'll just read it again just so it's more clear. We've been told that this bill will not create systemic vulnerabilities. So what I'm asking is, does mandating interception capability inside an encrypted system fall inside that definition or outside?
So when looking at the definition of systemic vulnerability, and there might be amendments that speak to this as we move along, and the minister has spoken about this publicly, that systemic vulnerability is understood to mean, from a government perspective, that it is not targeting end-to-end encryption. And as such, your question whether or not the answer to your question will depend on a specific situation, that if the regulations mandate something, or if a ministerial order mandates something, the core provider or the person or the company that's subject to the ministerial order will not have to do anything if it creates a systemic vulnerability into their system. And so that is what the definition, that's how the legislation in Part 2 is constructed, and there's a process for developing regulation that everybody's familiar with in terms of that. But then ministerial orders have a very specific process that involves the electronic service providers, that involves the law enforcement, the minister, the intelligence commissioner. And so there's a process there. And at any point in time during that process, if an electronic service provider says to us, because they know their system best, that introducing or a capability would create a systemic vulnerability, then there's an opportunity then to address that and make sure that it doesn't.
So a law describes what should happen and sets out consequences when things go wrong, but it does not physically prevent an attack from occurring. The assumption this bill seems to rest on is that if the rules are clear enough, the infrastructure will be safe enough. But rules do not stop a breach. They describe what happens after one. The people targeting Canadian systems do not factor in what Parliament has passed. They look for a door. This bill requires that door to be built into every qualifying service provider. What in this bill, not the rules around it, but the technical reality of it, actually keeps that door from being found?
So I think just to take a quick step back, the legislation does not, it won't apply to every single electronic service provider from day one, right? And so an electronic service provider, for it to be covered by the legislation, would have to either be covered as a core provider to the regulation, number one, or number two, through a ministerial order, they would need to be identified to develop any capability that is mandated by the regulation of the ministerial order. The legislation is intended not to introduce systemic vulnerabilities into systems. We don't refer to backdoors. We don't believe it creates backdoors. I think there's a letter from the CSC that was shared with the community on some of these points. It is the responsibility, whether it's with this regulation, this legislation, but as it currently stands, for companies to protect their cybersecurity. They do it every day. Attacks happen. I think we had testimony before from my colleagues at the service that there is no system that is 100% protected from cyber breaches. I think that we all know that from what we see every day. But companies are well positioned to defend their systems, and this legislation has safeguards to prevent new systemic vulnerabilities from being introduced in systems.
Okay, on that note, like in 2024, Chinese state-sponsored hackers, specifically Salt Typhoon, got into lawful intercept infrastructure that had been built into American telecom systems. The access point that existed for authorized law enforcement became the way a foreign state got in. So Bill C-22 asked Canadian providers to build that same type of architecture. So did the Department of Public Safety do a threat assessment specifically on that scenario? And if they did, is there something that we can see?
So we're obviously aware of the information about Salt Typhoon. Without going into details of that specific situation and breach, I can tell you that we always learn from past breaches in different situations, and as the implementation of this legislation, should it become law, that is obviously something that we'll keep in mind and that we'll work with companies as the legislation gets implemented.
So the term electronic service provider in SAAIA is extraordinarily broad. It could capture telecoms, messaging apps, cloud storage, AI platforms, email services, and potentially much more beyond that. And many of those providers are not Canadian companies. They are headquartered in the United States, the European Union, or elsewhere, and operate under the laws of those jurisdictions. Can this committee get a clear answer on exactly which categories of service are captured under that definition and which are not? And does that obligation apply equally to providers headquartered outside Canada?
So I'll start and might go to my colleague Shannon Heigl, who's with us virtually today. As I explained earlier, who the legislation will end up applying to specifically will be determined through regulation and core providers. We've talked a lot about telecommunication service providers, probably being one of the most important electronic service providers that might be subjected to Part 2. But then in ministerial orders, we'll be able to identify electronic service provider after that. And so there's a process for decision making in terms of who it gets applied to in regulation, and the same thing for ministerial orders. As for differences in applications, whether or not they're domestic or international firms, maybe I can ask my colleague Shannon to elaborate on that.
Absolutely. Thank you for the question, Chair. I would be quite specific in pointing out that under electronic service provider in the Act, A refers to providing the service to a person in Canada, or B carries out all or part of its business activities in Canada. What we're trying to ensure is that Canadians can have the certitude that we are covering any type of electronic service provider that services and operates within the jurisdiction of Canada. So I think that's certainly an important definition and explanation to give you and related to your question.
Thank you. So anyone who's worked inside a data system knows that security gaps do not only come from outside attackers. Every time a service provider adds a third-party program, every time two systems get connected, every time a new software link gets built in to meet a requirement like the one this bill creates, a potential gap opens. The interception architecture, SAAIA, will not be built once and left alone. It will be patched, updated, and connected to other systems by providers of very different technical capacity. And each of those moments is an opportunity for a gap to open that nobody anticipated. Does this bill require any ongoing security testing of the interception infrastructure after it is built, or does the obligation end at construction?
I think this legislation is part of an ensemble of legislation, but I would point to you that companies already take a number of steps to protect their systems. They do so in collaboration with their own service providers, with third parties, with the Canadian Centre for Cybersecurity. They are good partners of the private sector, specifically on critical infrastructure. I would also point out Bill C-8, which received royal assent late yesterday, imposes a number of obligations on federal critical infrastructure owners, including cybersecurity, including in relation to third parties. And so I think we need to look at it in totality in terms of what is done by private sector and the obligations that they have in regards to other pieces of legislation, but also that it is their responsibility, and we know that companies do this. They want to protect their systems because it's good for them, it's good for their customers, and they are all constantly patching whether or not this legislation exists. And as this legislation gets implemented and there are discussions with the government in terms of the regulation and ministerial orders, again, the legislation prevents or allows ESPs to say that I can't do that because it introduces a systemic vulnerability. And so there's a number of safeguards in the legislation, but also in totality in terms of obligations that applies to a number of providers.
Thank you. You're saying that there's going to be a lot of security being looked at with the bill, but in August 2025, hackers got into the House of Commons by exploiting a Microsoft vulnerability and pulled employees' names, job titles, office locations, email addresses, and device information belonging to members and staff. Canada's own cyber...
Yes, MP Sima, MP Akan.
The last three questions and this one are irrelevant to the topic that we are studying on the clause. So if our Conservative colleagues are willing to be productive, I suggest them to get back to the topic. And questions on the clause, please.
Yes, on that point of order, MP Lawton.
Thank you very much, Mr. Chair. I would note that this morning the Liberal government House Leader put on notice a motion to silence debate and shut down this committee's work on it. So for members like Ms. Cody and I who have taken a keen interest in this bill and others, today may be our only actual opportunity because of what the Liberals are doing to shut down this committee's work. So for them to even further try to use their points of order to silence very legitimate questions on this bill is shameful.
Point of order, Mr. Chair.
Yes, MP Akan. It's the same point of order?
Same point of order, Mr. Chair. Again, we are studying clause by clause. We did hours of study in this committee for this bill, and I do suggest for us to be more productive instead of spending 11 hours last week on filibustering, to focus on the clause, ask for relevant questions on the clause so we can pass, and those questions will definitely have place to be asked.
Let me try to reconcile those two views. It's about freedom and focus, freedom to ask questions we want, but focus on the topic raised by a particular amendment. So if we want to have an efficient and productive discussion, then we need to focus as well as we engage freely on the topics of our conversations. But we have a limited amount of time, as we rightly said, MP Lawton, and therefore would encourage both freedom and focus. MP Cody?
I believe the bells are ringing, Mr. Chair.
So do we have unanimous consent to continue while the vote is going on?
No.
No.
So I hear we don't have unanimous consent, so we'll suspend. And once the vote ends, we'll have 10 minutes after the vote, and we'll resume again. Commençons.
So we will begin our sitting again. Thank you for being back with us. We are at Amendment BQ5. And I believe that Ms. Cody had nearly clued up her comments. If you would like to continue, the floor is yours.
Thank you, Chair. Through you, Chair, I definitely would like to have my comments, especially since it is our people who are asking for this information. It's not like they're just going to a drawer and making a request by a service provider and they pull out a file. It includes a lot of information going through systems and third-party softwares. So I think to be clear, we need to ensure that when people are asking for information and private information, they know what tools that are being used so they can be comfortable when they put that request in. So I'll continue with my questions. Because this bill requires service providers to build and maintain interception infrastructure from a production order as a permanent feature of their systems, the threat environment that an infrastructure has to withstand is directly relevant to whether this bill is fit for purpose. Published cybersecurity assessments have found that AI tools have made it possible for people with relatively modest skill to scope out systems, find vulnerabilities, and carry out attacks that used to require serious expertise and resources. The window between finding a weakness and exploiting it has narrowed dramatically. Was there any analysis done of what the interception infrastructure this bill mandate looks like as an attack surface in that kind of environment? And if not, what is the basis for bringing this forward without it?
Yeah, thank you, Chair, for that question. The focus of the legislation in Part 2 is really to establish a floor to provide capabilities to provide some of the information that law enforcement need to advance their investigations. And so at the end of the day, the legislation is about creating those conditions, but it's up to the individual companies who are going to be subject to the regulations and ministerial orders to determine how they meet those obligations and making sure that there are no systemic vulnerabilities into the system. And so that's the answer that I would give. It's hard to say, to be quite frank, it's hard to say, well, in advance, if you do it this way, this is the vulnerability, because ultimately the responsibility relies on the company to meet the obligations of a production order or a search warrant, or whatever the case may be, to provide the information that's being requested following judicial authorization.
Thank you. Through you, Chair. The security of the interception infrastructure this bill requires to be built to follow these production orders will depend entirely on whether that infrastructure can withstand the tools currently available to those who want to break into it. Before Claude Mythos was released to the public, it found a security flaw that had been sitting undetected in a widely used operating system for 27 years.
Oui, Monsieur le député Housefather.
Yes, Mr. Housefather. Microphone, please.
Microphone. I didn't get the translation.
Et j'entends très bien.
I hear your point of view, and so for this debate to be as efficient and effective as possible, and the chair cannot order this, but it is preferable to focus on BQ5, the amendment in question.
Again, thank you, Chair. I'm going to continue with my questions. These are questions I feel are important.
Oui, Monsieur le député Housefather.
Yes, Mr. Housefather.
Actually, do not believe that when you are on a specific amendment, you are allowed to stray off of that specific amendment to a point where you are asking about the bill as a whole that has nothing to do with the specific amendment. I really, Mr. Chair, would ask you to look at that question of whether or not these questions are relevant, because we have a choice, Mr. Chair. We can actually go through all of the amendments tonight. We have 7.5 hours to go through all the amendments, or we could do nothing and then be subject to a programming motion that will just have us vote only on amendments and not discuss them. So, Mr. Chair, please check the question of whether or not she has to stay relevant, because it's not relevant.
Député Lawton.
Thank you, Mr. Chair. Mr. Housefather wasn't here before when we had an identical discussion. And once again, we have Liberal members trying to silence very legitimate questions being raised by members of this committee. It was incredibly patronizing that Mr.
Point of
Housefather was
order.
asking you to check Ms. Connie's questions. I mean, if C-22 passes, the government can check whatever they want on people's devices, I guess. But these are incredibly important questions. And the fact that these Liberals are threatening, even in this committee process, to use the programming motion as a way to deny members the opportunity to speak is exactly why it is important to interrogate and scrutinize this bill.
Point of order, Mr. Chair.
Madame
Same
McCann.
Point of order. We had, as committee members, not only the Liberals, but Conservatives and Bloc, had lots of hours on this committee, and we did ask all these questions. And if we can just be relevant, because we are doing clause by clause, we are not doing a study, like a question period here. We are doing clause by clause. We have to stick to the clauses. We have to study the relevancy of the clause and ask questions that are relevant to the clauses so we can move forward. Those questions will be coming soon, and there will be time. If we can pass at least part 1 and move to part 2, then Ms. Cody can ask those questions when it's relevant. Thank you.
So I don't believe I need to repeat what you just said. I think these points are well stated, and I expect everyone to take them into account as they proceed efficiently through this meeting. Madame Kirkland?
Can I ask something here? I think that Ms. Cody is getting through her questions, and I think that it's possible she could get through her questions if she would stop getting interrupted, and we could move on and move on to next amendments. So I do think that she's going to get through her questions, and then we'll move on. So she has the right to ask them. I think we should just...
So that's, I understand, in
that's
addition
wise.
to that same point of order, MP Lawton?
Just in the spirit of collaboration here, Ms. Akan had mentioned the importance of passing Part 1. Are the Liberals taking us up on our offer to expeditiously pass Part 1, which we've been offering for weeks now, which is not even all that contentious? If that's the offer.
Point of order. Mr. Lawton should know very well that Part 1 without Part 2 is not a bill. Doesn't make sense.
My understanding of what MP Akan said is that if we want to proceed efficiently through Part 1 and eventually Part 2, then we have to do that in the sequence of the amendments, and that's therefore why it is suggested, though obviously not obligated by the chair, to focus on the topic of the amendment that is currently under consideration if we want eventually to proceed to other amendments thereafter. MP Cody?
Thank you, through you, Chair. In a matter of trying to collaborate with the members across, I will reduce the number of questions, but I do feel that there are important questions I do want to ask, and I'll continue with them, and I'll be able to continue quicker if their points of orders do not interrupt. So I think there'll be a fair compromise. So I'll continue. To go back to the question, the security of the interceptor infrastructure this bill requires to be built to follow these protection orders will depend entirely on whether that infrastructure can withstand the tools currently available to those who want to break into it. Before Claude Mythos was released to the public, it found a security flaw that had been sitting undetected in a widely used operating system for 27 years. It cost only $50 and took hours, where human researchers would have needed months. So just last week...
Point of order, Mr. President.
Oui, Monsieur le député Ramsey?
Relevant.
Yes, Mr. Ray.
So I understand you must be saying relevance to the amendment. Madame Cody, you would have heard that before.
Yep, I hear it, and you're asking someone to make an order based on what they believe, and to do that, they're going to use a tool, and they got to be confident that that tool is going to be accessing the information properly and correctly and accurately. And if you're going to have a judge who is looking for to be satisfied by the information on oath, these questions do need to be answered, so they are relevant. Thank you. So I guess I go from the top and continue again, and so that there's no miscommunication with the question. The security of the interception infrastructure this bill requires to be built to follow production orders will depend entirely on whether that infrastructure can withstand the tools currently available to those who want to break into it. Before Claude Mythos was released to the public, it found a security flaw that had been sitting undetected in a widely used operating system for 27 years. It cost only $50 and took hours, where human researchers would have needed months. Just last week, and released Claude Fable 5 and Claude Mythos 5, making that level of capability broadly available for the first time. The U.S. government's response was immediate, an export control directive forcing Anthropic to suspend global access to both models entirely. The first time a government has shut down an AI company's products over national security concerns. Has the Department of Public Safety looked at what AI-powered vulnerability discovery at that speed and that cost actually means for the long-term security of what this bill is asking to be built?
No, because the legislation does not mandate specific things be built. That will be something that will be done through regulation and or ministerial orders subject to that. And as part of that process, we expect security conversations to be part of the consultation process, whether it's with internal government experts or with the people that may be subject to regulation. And obviously, it's an evolving environment, and I am not one of those foremost cybersecurity experts, and I won't delve too much into that. But we will be consulting with experts as we move forward, and subject to the regulations that will dictate how we approach it.
Okay, because one of the core assumptions underlying this bill is that data only moves when someone with legal authority requests it. But the infrastructure SAAIA creates will operate in an environment where that assumption does not hold. Claude Mythos did not wait to be asked. During a controlled stress test directly relevant to the kind of security environment this bill's infrastructure will face, it decrypted...
Sorry, Madame Cozy, what you're saying is both dense and quick, and I suspect that it must be quite difficult for interpreters to follow the rhythm.
Okay. I will just trying to hurry to go through. But anyways, one of the core assumptions underlying this bill is that data only moves when someone with legal authority requests it. But the infrastructure SAAIA creates will operate in an environment where that assumption does not hold. Claude Mythos did not wait to be asked. During a controlled stress test directly relevant to the kind of security environment this bill's infrastructure will face, it decrypted and exposed confidential internal documentation on its own, following its own logic to a place nobody directed it to go, and then flagged to a researcher that it had gotten out. That is not a malfunction. That is the system working as designed and going further than anyone intended. And Claude Mythos is not unique in this. AI systems of this capability class, built by any number of companies in any number of countries, operate the same way. The interception infrastructure this bill creates will exist in an environment where AI systems can reach, surface, and expose data without a request, without authorization, and without anyone knowing it is happening until after the fact. Where in this bill does the government account for that?
Maybe first I'll clarify that the legislation that's being discussed today does not create a surveillance infrastructure. It does not mandate specific types of capabilities. That's a process that will be done through, or not even done through regulation, because it will not mandate a massive surveillance infrastructure. And as the development of the regulations proceed, security will be part of that process. Systemic vulnerability analysis will be part of that process. And I will also say that the legislation creates a framework for companies that will need to be followed to level the playing field in terms of being able to provide this information. And the information will only be provided to law enforcement if and when there's a judicially authorized production order to do so. And it'll be up to the company at that point to decide or to fulfill their obligations under that court-ordered production order. And at the end of the day, as I said earlier, the companies right now already have a lot of this data that might be subject to the regulations and to ministerial orders, and they already take a number of steps to protect that in the face of the threats that you just mentioned in terms of AI capabilities to sniff out cybersecurity vulnerabilities. They are very good at protecting their systems, and they continually try to get better by engaging third parties, but working with folks like CSIS and the Canadian Cybersecurity Center.
Thank you. When a production order is requested and the officer is believing that there's a reason to pursue or to inquire, SAAIA does not appear to draw any practical distinction between the data of a person who is the subject of a production order and the data of innocent people who share an account with that person. I see that as a significant gap. Most Canadians share phone plans, cloud storage, and digital accounts with family members. A production order targeting one person on a shared account does not stop at that person's data. It pulls everything on that account, including the private information of people who have never been suspected of anything and have no idea an order was ever made. The bill may intend for providers to limit disclosure to what is ordered, but the technical reality of shared accounts is that one person's data cannot always be practically separated from another's. Canadian law already recognizes this principle in other contexts. A joint bank account holder cannot be compelled to hand over funds or information belonging to the other holder simply because that person is under investigation. Why does that protection exist at the bank, but when it comes to a telecom or a digital service provider, where a family shares an account, the technical architecture makes that same separation nearly impossible? And what enforcement mechanism in this bill ensures providers actually achieve it?
Thank you, Chair, for the question. The bill doesn't speak to production orders or doesn't address tools that, whether it's CSIS or law enforcement, already use to compel production of information. And so the situation that you describe exists today in normal in the current environment, whether it's telecommunications or others. So I might turn to the RCMP just from a practical perspective, how you deal with that, and maybe I don't know, maybe Justice or the service can add on to that, because it is more of a question about how production orders are applied for and given by the judges.
I appreciate the question, Mr. Chair. Essentially, well, I actually very much appreciate your highlighting, Minister, the complexities that police are actually currently dealing with. So this is something that, as mentioned by my colleague previously, is that we actually regularly deal with. And that's part of why we have experts who do analysis on the information that we actually receive. And their intention is to establish who might be the originator of a particular type of traffic. And that speaks to the information that we actually request when we're asking for information, for example, like in production orders. Because it's not just the information related to the actual offense itself, but it's also information related to the use of a particular device at a particular time in a particular place that we try to collect. And we use that for attribution to a particular individual at a particular time. So this is something that we're actually very familiar with, and we do it on a regular basis. But I very much appreciate your highlighting the complexity.
So the National Security and Intelligence Review Agency, the body that would be expected to oversee the authorities, has raised concerns about whether it has sufficient access to do that job effectively. At the same time, SAAIA stops service providers from telling anyone that a demand was ever made against them, so the public does not know. The oversight body cannot fully see. The companies cannot say anything, and the person whose data was accessed may never find out. How does that combination produce real accountability, and who exactly is in a position to catch a problem if one comes up?
Monsieur Housefather?
Mr. Chair, I respectfully listened to Ms. Cody's last question, the same as her others. We're now in a section where we're making a determination whether we should amend reasonable grounds to suspect to reasonable grounds to believe, which is a debate about what legal standard to apply to part of this bill. It's a very important debate. It's a very important discussion, but this question is entirely unrelated to the discussion, which is the purpose of this amendment. If Mr. Chair, these questions are allowed, then it means that these same questions could be repeated with each and every amendment and each and every sub-amendment that is introduced, irrespective of the relevance to that amendment or sub-amendment. And I would respectfully submit, Mr. Chair, this is not how clause by clause is supposed to proceed.
Exactly.
That's right. So there's part of the blame is on me, and I appreciate that. I have also the responsibility to allow some freedom, but it is true that if we want to vote on a particular amendment, the topic of the discussion needs to be on that amendment. Otherwise, we will never proceed to the consideration of other amendments. So if we want to consider Amendment BQ5, then I would certainly encourage everyone to focus on the topic, the content of that amendment in the questions and answers.
Okay, I will conclude with the last two questions then. I've had several and I've turned them away, and I do feel that these are correct to ask because you are asking our law enforcement to believe in what they put in the order, and to do so they have to understand and have confidence of what they're going to be retrieving, of the accuracy and what may or may not happen before they do it. So I do think that it does have some relevance to believing, and so I will continue. So the United States just demonstrated that it can shut down AI tools used by Canadian service providers overnight with no notice and by executive order. Canada is asking those same providers to build and maintain permanent interception infrastructure under this bill. What is the government's continuity plan when the tools a service provider depends on are switched off by a foreign government's decision? And does this bill create any obligation to disclose that kind of disruption to the people whose data sits behind it?
Question. The bill doesn't address that. It's not within the scope of the legislation.
So, again, I'm going to mention about Anthropic itself flagged the cybersecurity risk of Claude Fable 5 and Claude Mythos 5 before the United States government acted. The company raised the alarm first. The U.S. ban came within days of release. Canada has said nothing. This bill asks Canadians to trust that the government understands the AI threat environment well enough to build permanent interception infrastructure inside it. But when the company that built the tool and then a foreign government both moved before Canada even asked a question, that trust has to be earned. Is the government's position that it needs a foreign government to identify an AI national security threat before it will act? And if that is the standard, how many days behind Washington should Canadians expect their government to be?
Deputy House Father.
Doesn't matter. It's not relevant.
Mr. Chair, the people there are not there to answer for the government as to the government's intentions on something that has nothing to do with this bill. That is a question she could ask in question period. This is not a question for these witnesses on a subject that is not part of the bill. She's asking them a much greater question about a government's intention. The question is unreceivable.
And that is a risk, indeed, of asking those types of questions, but obviously you are free to ask them, and then we'll see whether the answers are either reasonable or up to the expectations that you're setting. Madame de Bellefeuille?
Moi, je peux vous dire, là,
Yes. I would like to just let you know that fast reading is very difficult, and Mr. Housefather also speaks at the speed of light. The interpreter who is serving me is so good. I'm sure she will not still be standing upright by midnight tonight. If you've noticed as well, I don't have a headset on today with 2 ears because those have not been tested for safety for interpreters. So I do have my one-eared earpiece, so I would ask my colleagues, both CPC and Liberal, to slow down because they need to speak more clearly so that I'm able to participate and be included in these deliberations. Thank you. And that is a point of privilege that the member has just raised. It pertains to the 2 official languages, and a question regarding access to deliberations in English would also be fair. And Ms. de Bellefeuille often sits near members who have a tendency to speak quickly, so please keep that in mind when you're taking the floor from now on. Ms. Cody?
Or is that, as you said, the end of your questioning?
I do have one more relevant question. Thank you. I would like to know if there is going to be a more clear definition, and will belief be strong enough for an arrest, or could it be suspicion or a thought? And is there a risk that belief will come from false accusations, an act of bad faith of someone who wants to create distress upon another person?
I'll go to my colleagues on RCMP. I mean, when you're going to a court to apply for a production order on reasonable grounds to believe, there's a robust process to draft up affidavits and get a judge to sign off on that. And so maybe what that means in practice, Sergeant Gilks?
Sorry, if you could just repeat that question, please.
I was just wondering if there's going to be a more clear definition of believe, because it could be suspicion, it could be just a thought of someone. Like, is there a risk that when you're going to be making an order, a production order to investigate someone, that it could be from a false accusation, an act of bad faith of someone who wants to create distress upon another person. We've seen complaints be called in, a neighbor upset about someone. And, so when you have a word that is so vague like believe, what definition are we actually going to use and follow to ensure that the strength of believe is something that is going to be enough to warrant an investigation and not just chasing someone down a rabbit hole?
Thank you for your question, Mr. Chair. So essentially, especially if we're going to be presenting our information to obtain to a judge or a justice, they have a guideline themselves, which is in fact subjective, but they were trained to properly assess whatever grounds are being put before them, and they have their own tests which will test whatever grounds are being put before them, and they will attribute the level of grounds which have been or have not been met. We can only present what we learn, what we collect in terms of evidence, and if it does not meet the grounds that the judge or the justice feels that it's either to suspect or to believe, then it's simply not signed and it's simply not attributed or active as a warrant.
Okay, I'd like to thank all of you for answering all these questions that I had, your patience with it, and I will conclude.
Thank you, Madame Cody. Monsieur le député Ramsey.
Mr. Ramsey. Well, it's going to take an effort for me to be able to remember, because we went all the way to Timbuktu, and now we're coming back to BQ5. It's line 27, page 7. We substitute one word, reasonable grounds to believe, which would be changed to reasonable grounds to suspect, followed by two conditions. An offense has been or will be committed under this act or any other act of Parliament, and B, the subscriber information is in the person's possession or control and will assist in the investigation of the offense. And Mr. Gilks, I believe, spoke to us about, among other things, a file of child exploitation online in which, indeed, this amendment, so reasonable grounds to believe, would require much a higher threshold before being able to verify an identity in question. So I don't want to presume. I would put my question to the RCMP witnesses. The following question: how many crimes per year in Canada occur when they have to do with sexual exploitation?
Yeah, we wouldn't have the number for you on that question, Mr. Chair.
Est-ce qu'on veut parler de milliers de...
Are we talking about thousands of cases?
I think the bells are on now, and could we look for unanimous consent to continue our study?
Certainly do that. Is there unanimous consent to continue the proceedings? No, so there is no unanimous consent, which means that we'll need to stop now. I suppose there might be a bell. Whatever happens, 10 minutes after the vote is the maximum time I will be waiting for people to come back. And if everyone is back, then I'll start before. Merci d'être de retour.
Thank you for being back with us. We will get started again. We are continuing Mr. Ramsey's intervention. Mr. Ramsey, the floor is yours. Yes, thank you, Mr. Chair. First of all, I would like to say that I challenge your statement that at the pace we're going will end in 2028. I would say 2029. We still have not discussed this amendment in this sitting. We're talking about a simple amendment. And Mr. Gilks was explaining something to us. He was saying that this, he was talking to us about sexual exploitation cases involving children online. And this type of issue should find unanimous support. I know that you do not have this statistic, but if I were to ballpark, is it around 20,000 a year? Am I far off?
For the question, I still don't have exact numbers for myself from our RCMP units. However, I would like to call on my colleagues from Justice just to repeat. They did have some Eurostat statistics on that from the other day. If they could repeat that, and then I can speak to context.
If I may, Mr. Chair, thank you. Just some few statistics from a variety of sources. So from the Canadian Centre for Child Protection, who I believed appeared as a witness here, they receive about 23,000 in 24, and these are all reports they receive from the public that they refer to Canadian law enforcement. The National Center for Missing and Exploited Children in the United States refers approximately 100,000 child sexual exploitation cases to Canadian authorities every year. And the Eurostat reported police incidents were approximately 17,000 reports last year. Importantly, 94% of these cases are not cleared by police because either insufficient evidence or the impossibility of identifying criminals. I would also like to add on, and it doesn't have to do with child sexual exploitation, but in terms of internet fraud cases, only about 5% of internet fraud cases are reported at any given time. In the first 3 months of this year, there were 8,000 reports that were processed by police, totaling $188 million. In 2025, that was almost $800 million, and again, that's only 5% of internet fraud cases. Thanks.
Mr. Chair, I would suggest that those figures are particularly telling, and I would exhort our colleagues across the way that they should not have a reflex to vote against an amendment that is extremely simple. We're talking about amending one single word. We're talking about access to data and intelligence promptly. That is what is going to allow us to go forward. And I would like to hear our witnesses from the RCMP on this. It is the ability to react swiftly that will make it possible to halt cybercriminals, among others, under the criminal code in sexual exploitation cases. These are not small numbers. We're not talking about 10 kids. We're talking about thousands of cases. So if we are serious about fighting crime in 2026, and we agree with these figures, then we agree with C22.
I am confused. Are we not talking about BQ5?
Absolutely.
And so you're going to support...
Absolutely. Please listen to what I say. Je parle en français. Peut-être que vous avez besoin de votre oreille.
I'm speaking French. Perhaps you require your earpiece.
Oh, très bien. On revient.
Non, mais monsieur, il parle des heures. Il parle des...
They have been going on for hours, and then they respond to me in this way. I'm talking about BQ5, changing the word suspect to believe.
Très bien. Madame Kirkland, if you have a point of order, please state it.
My point of order is I would like to be treated with respect. I'm simply asking for clarification. Are we talking about BQ5? Because he said he would support the amendment, which I was surprised, so I'm trying to understand. Thank you.
Okay, good. So the question is whether you are speaking about BQ5, which is a relevant question,
Okay.
not necessarily a point of order, but a question which
clarification, I guess.
un point d'ordre ou un commentaire que
This is a comment, and Mr. Ramsey may wish to take that into consideration. Mr. Ramsey, the floor is yours. So I will address myself to our witnesses from law enforcement. Here's my question. Is it important to be able to respond quickly when we look at Amendment BQ5? If we change the wording reasonable grounds to believe to reasonable grounds to suspect to believe, is it true that currently fewer cases are unable to be concluded? So if we change that wording, am I right in deducing that more criminals will be able to be caught in cybercrime cases or fraud cases?
Yes, thank you for the question, Mr. Chair. And in speaking to the tools that are proposed in this legislation, the reasonable grounds to suspect in the confirmation of service and the subscriber information production order would, because of you're at the very beginning of an investigation and you're just looking to attach somebody to a device that's been reported in a criminal offense, then yes, it would speed up that process and help assist with the backlog of cases, most certainly. The threshold of reasonable grounds to believe is a much higher threshold. So at the beginning of investigation, to try to get to that level with the complexity and the volume of complaints in online crime, it would be very difficult, yes.
Mr. Chair, I think we have just clearly heard that in this whole debate over reasonable grounds to believe versus reasonable grounds to suspect, we clearly understand why C-22 is adopting the wording suspect, because there are issues at play here that involve thousands, I repeat, thousands of crimes that will not be able to be concluded. And the security of Canadians is important to us. That's why it's important for us.
Et nous allons défendre ce principe.
And we are going to defend this principle. And our colleagues across the way have literally rejected this with their debates today. Thank you, Mr. Ramsey. I have Mr. Lawton and Mr. Au. Mr. Lawton, please.
Mr. Chair, just to whichever official, perhaps one of our witnesses from law enforcement, can you please give an example of, if you have a concrete one, that would be ideal, but if you need to go into the realm of hypothetical, I would understand it, of someone who would fall between the two thresholds at issue, the two evidentiary thresholds, the one originally put forward in Bill C-22 as drafted by the government versus if amended by Madame de Belfoy's amendment. I basically want to know who's being captured by one definition but not the other that would justify changing or not changing it.
I suppose I would return to a previous example which I've used, which would be someone making a complaint that they've been defrauded at a financial institution. So there's money missing from their account, and they're alleging that someone has defrauded them of the funds. But there might be an allegation from the bank or a counter statement provided by the bank stating that they actually believe that the individual is the one responsible. So at this point, we cannot necessarily say that we believe that an offense has been committed, but we do suspect that maybe one has been committed. So we can't automatically take one person's word over the next, and we are not at a stage yet. We don't have enough information to actually make that assertion, and we start to build our grounds by collecting information, and some of that would be subscriber information.
But just following logically, reasonable grounds to suspect people that follow fall into that bucket is going to be a fundamentally different number of people, a different number of suspects than in reasonable grounds to believe. So in one, you're going to have a broader net, which means just statistically, you're going to have more people captured who are not criminals, who are not going to be charged, let alone convicted. Do we have any sense of how big that pool is going to be? Because we're talking about who these extraordinary powers that Bill C-22 is granting authorities will apply to. And no one has issues with laws being used against people that have broken the law. We do have issues with laws like these being used against people who haven't. So how many more people in that category are going to be caught with this definitional change if Madame de Bellefeuille's amendment is not put in the bill?
Well, I can't really speak to exact numbers, but we did hear from our colleagues at Justice the numbers of cases that are not going forward as a result of not being able to confirm basic information at the beginning of an investigation, because this information has to be obtained in a timely fashion, just because of the nature of and the speed of and the complexity of the investigations that we're currently seeing. So I can't speak to an exact number. The difference that would be caught there. But I can speak to, in terms of your grounds to suspect, once again, the production order itself is scoped in a way that it's not providing content of the information or of the accounts that are being held by the individuals, but it's providing identifying information as to who the account holder might be or the services that are actually provided, which could allow for connections to be made, which could allow for assertions and corroborations to be made with other information that's been received early on in an investigation.
I suspect I will probably have some more questions when we get to the overarching question about Clause 6, but I appreciate that on BQ5. Thank you, Sergeant.
Just supplement to your question, if I can be helpful, because I think you're asking an important question, but I do want to make sure that I put it in context of, because our colleagues from the RCMP talked about this in a previous meeting. They're gonna have a device number, for example, and they're gonna go and ask a provider if that belongs to them, Rogers, for example. And then they're going to, if the Rogers says, yes, that's my device number, they will ask a judge to issue a production order on a reasonable grounds to suspect, to get subscriber information for that particular device. It won't be associated with 50 people or 100 people. It'll be directed only at that device number to get subscriber information for that device number. And that will be related to that investigation. So the way you were asking your question, it's not a basket of people that you capture. It still has to be grounded in a specific crime and specific to that information that you're trying to get. So I just wanted to provide that clarity.
I appreciate it. Sorry, what I was referring to was the aggregate of people suspected of different crimes by different law enforcement. I'm talking about not the Venn diagram, if you will, but the concentric circles of people caught in, beyond a reasonable doubt versus, reasonable belief, reasonable suspicion. But I appreciate your contribution there. So yeah, I'll yield it at this time. But again, when we get to Clause 6, I feel like depending on how the Liberals vote on what I think is a very good amendment, we may have further questions.
Merci beaucoup, Monsieur le Député.
Thank you very much, Mr. Lawton. Mr. Au, please.
Yes, thank you. I have many questions, but I just want to ask one question for now, based on the answer given by Mr. Wong to MP Ramsey's question. So it's a follow-up of the previous question. I get that, there are numbers. You can talk about hundreds or thousands of cases which cannot be completed for investigation for many reasons. So you gave the number, but I did not see the connections between the threshold for asking information and the number of cases that could not be further investigated. So there may be thousands of cases you cannot complete the investigation. But the question is, how many of them, or what's the percentage of those dead cases was caused because of you do not have the reasonable ground to suspect in order to get the information. So I don't see the causation here. The numbers of cases could be great, big, but what is the actual percentage of cases which could not be investigated further due to the obstacle that you mentioned?
Thank you for the question, if I may. Perhaps I wasn't clear when I spoke, but the recent Jurostat report said 94% of cases were not cleared, and this is child sexual exploitation cases. And the two main reasons they gave was that they had insufficient evidence, so they couldn't meet the evidentiary threshold to be able to get probably the next tool, or they were unable to identify the suspect. So those are the two main reasons why 94% of child sexual exploitations are not cleared. This subscriber information production order is designed exactly to help police lower that number because it will provide quicker access to evidence so that they could identify the suspects and decide whether or not to pursue an investigation. I would also like to say, in terms of the example that Sergeant Gilks gave, it's important when tools that the police use might generate other leads. So you know you're investigating a bad guy, and that bad guy has known associates, or he's phoning other people. And some of the tools in the criminal code allow us to monitor the activities of these bad actors. Those numbers that are generated are the types of identifiers that need to be tied to an individual. So a lower threshold tool with specific information allows police to only get the identifying information so that they can identify who's on the other end of that number. The tools that are available for them today are the general production order, and that would allow police to access any and all information when they can eventually reach that threshold. That's a longer process, but it's also much more privacy invasive for the pizza delivery guy who the bad guy called. Because instead of saying, oh, he's the pizza delivery guy, he's no longer a suspect, this is the pizza delivery guy that the police now have all the information on. So these tools are not only meant to provide police with greater flexibility and agility in investigations, they're also meant, because they're specific production orders, to protect privacy.
Well, Mr. Wong, I think you have opened up another can of worms. You know, by what you just mentioned, you're saying that one can lead to the other and to many, many other. This is exactly why, we are being cautious. You're just telling me that this is a way to open up the gate to investigate many more people who might or may not be associated.
If I may, these tools have existed in the criminal code for many, many years. So this tool that I'm speaking about has existed in the criminal code since 1993.
But again, the difference is in the threshold.
These tools are available under reasonable suspicion.
Right. Okay. Now, I want to ask another question because of time. Even if your logic is right, you can make that connection, saying that, look, it's because of the high threshold, you cannot get on to further investigation. However, that doesn't mean it is a legislative problem. It can be a procedural problem. You cannot get the order from a warrant or whatever you need to have to further investigate. It could be lack of resources. It could be, the work hours, and the judge might be on leave, on vacation, or it could be, many other reasons that you cannot get that kind of permission or authorization in time. So that doesn't mean it's a problem in the law itself. It could be a problem in the administration. It can be a problem of the procedural or a problem of resources. So why do you need to change the law and not a review of your procedures so that you can get the information through the legal means faster, in a timely manner, instead of making this big hole and open up, many cans of worms.
Thank you again for the question. All of the procedures are actually statutory. They're in the criminal code, and it's been since 2014. My colleague has mentioned this, and I think I have too. The Supreme Court decided in Spencer that there was a gap in the law, that the police's common law power was insufficient to get this information, and absent a reasonable law, police have had to avail themselves of the general production order. So this gap has existed in the law for the last 12 years. So I'll just stop there.
Okay, so, yeah, I have questions further down the road.
Thank you, MP Al. So would BQ5 be adopted? Oh, yes, I forgot to mention, we have a recorded division being asked. I forgot to mention that CPC4 and NDP4 are identical to that motion. So the vote on that motion will therefore lead us to skip NDP4 and CPC4 being identical. Monsieur le greffier, merci de procéder.
Mr. Clerk, please proceed to recorded division.
Just un instant.
One moment, please.
On the motion, shall BQ5 carry? Mr. Ramsey.
Contre.
Mr. Housefather. Mr. Pileski.
Against.
Ms. Akan.
No.
Madame Dandervan. Ms. Sodi.
No.
Mr. Mantle.
Yes.
Mr. Lawton.
Yes.
Ms. Kirkland.
Yes.
Mr. Au. Madame de Bellefeuille.
Non, 6 pour 5.
Merci, Monsieur le greffier. La motion.
Thank you, Mr. Clerk. The motion is defeated. Amendment BQ5 is identical to what we just dealt with, which brings us to BQ6. Ms. de Bellefeuille, would you like to move BQ6? Yes, certainly. Thank you, Mr. Chair. So BQ6 means that the order cannot look into medical information, among other information. And Mr. Chair, this is a recommendation that comes from the Privacy Commissioner. It seems logical to me that this type of information, including client privilege between a lawyer and their client, should also not be able to be accessed. So I wish for my colleagues' support. Thank you, Mr. Bellefeuille. Mr. Lawton.
Thank you very much, Mr. Chair, and thank you to Madame de Bellefeuille for introducing this. I just want to ask the officials a couple of questions. Do any protections like this exist elsewhere, to your knowledge, in other statutes under other circumstances?
There is a general provision that applies to all production orders in the criminal code that allows the person served with the production order to object on the grounds that information is privileged. So as far as lawyers are concerned, this is already covered, and that's found at 47.0193 of the criminal code, so this already exists. In relation to the clinics and that, we've heard testimony before, and there are uses for a production order to be used against medical clinics or other things because of insurance fraud and that. And again, this is a judicially authorized production order, So the judge has the final say whether or not the information sought is appropriate.
So you had indicated, Mr. Wong, that a solicitor, I think you were speaking specifically, if I'm not mistaken, about the solicitor-client angle at first. You said a lawyer could object to an order, but they would not have a guarantee of being successful in that. Is that a correct interpretation of your comments, that the onus is on them to prove why that privilege needs to be invoked?
Yes, but there are certain rules against getting production orders against lawyers' offices and certain procedures that have to be gone through. This is with respect to people who usually who receive these production orders, and they have the ability to object on that basis as well.
So just from what you're saying, though, this is not redundant. This is actually shifting the situation quite significantly, it would seem, because now there is a statutory exclusion under this amendment. So it isn't just replicating what's already in law, is it?
In terms of what its objective is, it may be redundant in relation to its scope. As I mentioned, there may be many reasons why police might need to serve a production order on a health clinic, so it wouldn't be redundant in that way, but in relation to the solicitor-client information, it may be redundant.
This will sound like a, well, I hope you understand that I'm asking this question seriously. Is medical information defined, or is that term in and of itself subjective in your view as to what would constitute medical information if this amendment were adopted?
Medical information is not defined to my knowledge in the criminal code. Generally, the courts use ordinary dictionary meanings of things, so it could be broad or it could be narrow depending on the court that is interpreting it.
Because there are, I mean, look, if we want to look not too distantly in the past, there was a period in which, vaccination status was actually highly germane to some regulations and restrictions on where you could go. And I know one of the concerns that's been raised in relation to the broader issues of C-22, specifically looking at metadata, is that location data would be retained. And I know that if we are talking about the type of information that could be made available, there are a lot of people that would be very mindful if vaccination status were going to be subject to it, if other medical decisions, choices, things like that are. So, as worded, would this protect someone from having to disclose, or from having to, would it protect the information of someone related to vaccination status from being disclosed as part of a production?
I would say that type of information is not available under the subscriber information production order. The subscriber information is defined. So vaccination status would be more privacy focused, and if police required that information, they'd have to get a general production order under the higher reasonable grounds to believe standard.
So again, I mean, we've had a lot of, I would say there has been a lot of discussion in this committee and also elsewhere about exactly what information is contained in that, and I do take your point. So if there is no risk that medical information would be transmitted as part of this, what would the harm be in making it crystal clear that information is safeguarded? And the same is true of solicitor-client information. If the view is that this information is not really at issue in what would be contained in subscriber details, why not offer that assurance that these pretty critical details will be protected?
All I can say is that it would make it inconsistent with other provisions in the criminal code, which could lend to the interpretation that that type of information is disclosable for the other provisions in the criminal code, so all the other production orders. So I think, as I started off with, it creates a bit of a redundancy in relation to the aspect of solicitor-client information. And as I mentioned again, there may be many reasons why police might want to confirm that a suspect is a patient at a particular clinic so that they can get subsequent types of production orders to obtain more evidence.
So my understanding is that there is a lengthy body of evidence about solicitor-client privilege, and it isn't just about communications between lawyers and their clients, but even the identity of clients. Am I understanding that correctly?
Yes, but I'm not an expert in solicitor-client information.
Understandably so. I appreciate you sharing your expertise on all of these things. Where my question is stemming from, and if there's one of your colleagues that's more suited to answer, that's fine, is that because a lot of the information that we're talking about, just going to metadata for a moment, is which phone numbers have been in communication with others, that could reveal a relationship that would be privileged, could it not?
It could.
Yeah. So if we are trying to protect solicitor-client privilege in explicit terms, I do think Madame de Belfoy is right to put that in clear language. I know that the Supreme Court has held in the past that, this is a principle of fundamental justice. This is actually under Section 7 of the Charter. It's a hugely important right. I am not a lawyer, but being in politics, I have the misfortune of working alongside many of them. And I greatly appreciate and respect a lot of what my colleagues do and what you all do. And I thank you for it, all jokes aside, being married to someone who's soon to be a lawyer as well. So I guess if we are saying that the principle, and what I take from your earlier comment, Mr. Wong, is that we, as a principle, are trying to protect solicitor-client privilege, and we have mechanisms to do that already, why not spell it out explicitly? And I know that's a point of argumentation on the merits of the amendment, so I'll make that rhetorical instead of getting you to weigh in on that. But I would encourage my Liberal colleagues to very strongly consider supporting that, and I'm willing to hear from other colleagues on this from different parties. I would also point out that medical information, because a lot of the opposition to Bill C-22 has come from people who fundamentally distrust this government. And I would say, having seen what this government has done and is trying to do in other bills with good reason. So if we are trying to safeguard and remove the reasons that Canadians are distrustful of this particular legislation, I don't know why we would not want to make it airtight, especially if the official position of the government is that, well, none of these things would ever be conveyed in this process anyway. Why not spell that out? So I think it's reasonable. I am open to hearing arguments to the contrary. I will yield at this time, but I think it's certainly merits consideration by my colleagues from the Liberals.
Thank you, MP Lawton. I have MP Mantle and MP Housefather.
Thank you, Mr. Chair, and thank you again to our witnesses for appearing and providing their valuable feedback and testimony on these different portions of the bill. I wonder if our colleagues from Justice could just, my understanding, and I'm not an expert on solicitor-client privilege as well, other than when I used it as a lawyer myself and had to engage in that. And to Mr. Lawton's point, yes, the identity of a client can certainly be privileged, and I've had many cases myself where the identity of client is an important factor to keep confidential. Of all the sort of standards of confidentiality, my understanding has always been that solicitor-client privilege is probably at the top of the list. Is that a fair assessment? Maybe Ms. Gibner or Mr. Wong?
Sorry, can you repeat that? I was trying to get help from my colleagues in behind as you were asking the question.
Get as much as, yeah, sure, bring them to the table. I guess my view has always been that solicitor-client privilege is sort of at the top of the list of confidentiality that can exist between two people.
I would say it is, and there is a partial provision in the criminal code that talks about searches on lawyers' offices. So when we're talking about the subscriber information production order, we're not considering it being served on production orders because there's a special process anytime a lawyer's office has to be searched. So this is when police do not know that a prior privileged situation exists, and it allows the holder of the information to object on that basis. And I believe Madame de Bellefeuille's amendment speaks to that same objective.
Yeah, I don't think the issue is, as I see it on this amendment, that somebody who's in receipt of a production order and thinks that it may disclose, information that's subject to solicitor-client privilege couldn't object. I mean, I would assume, regardless of what type of production order or demand for information you receive from any government authority or otherwise, you could always raise an issue of solicitor-client privilege, right? So it's after the fact, you could always raise it. Nodding heads. Okay.
You can. Yeah.
Yeah, and I raise that because it's not after the fact that's at issue. It's signaling to those who are making the production orders or who are considering what type of the scope of information or the place to search to make that very clear that that type of information is off limits. So I think it's sort of more of a signal, I think, in the law. And I want to ask a couple questions about, because you made a comment that that in your view it might be redundant. Is that right, Mr. Wong?
Yes, but if I could briefly comment on what you were talking about, and I think Sergeant Gilks talked about this earlier. When it's at the beginning of an investigation, if it's nothing but numbers, police have no idea what those numbers relate to because they don't know who the people who are implicated in the investigation are. So part of, I think, the issue with this on the front end is that police don't know what they don't know. So they're trying to identify the people that are implicated in the offense. And, even if this were here, they would not be able to determine whether or not it was a medical clinic that's attached to the phone number or a lawyer's office. They don't know until that information is produced.
So why then in the confirmation of service provisions of C-22 are there specific carve-outs for solicitor-client privilege?
Those carve-outs relate to who can be served with the order. So the confirmation of service demand, or as it was called, the information demand in C2, was a general tool that could have been served on any provider of public services. Generally right now in the C-22 version, because it's limited to telecommunications service providers, that articulation or that clarification is arguably unnecessary. But I think the government wanted to make it crystal clear that they were listening to stakeholders and made the carve-out because most medical clinics, as far as I know, are not telecommunication service providers.
Thanks for that. I think you're agreeing with me. I mean, the government, at least with respect to the confirmation of service demand, did include that very clear marker to say, and it's not just with respect to it can be requested of. The section doesn't make reference to it's being requested of. It just says that a demand must not be made if the confirmation would disclose the information. So I think you're quite right that that was made on purpose to signal that this information, medical and solicitor-client privilege, off limits. And I think what we're suggesting is what is the downside of doing the exact same thing for arguably the more intrusive tool, which is the production order. The confirmation of service demand is certainly less intrusive, we've established, than the production order itself. So why not make that same declaration here that we have that information, again, out of scope?
Thank you again for the question. I think the difference is under the confirmation of service demand, it's a statutory power for the police to exercise without judicial supervision. Here, when we're talking about the subscriber information production order, it's at the discretion of a judge. And perhaps I can point back over to my RCMP colleagues to give some examples of instances where they may need to serve it on medical clinics or other clinics or other areas where this might be relevant. But in terms of the difference between the two, I think there was some concern by the government that because it's a demand, a police officer statutory power, that wasn't sufficient supervision. But because this is a production order, it fits in the realm of all the other production orders and benefits as well from all the general provisions in the production order scheme.
Thank you for the question, Mr. Chair. I suppose for us, the challenges that we see, particularly, for example, like medical records, and this is an example that you can see in the case of an assault where an individual who's a suspect of the assault or the suspect of a particular crime has been injured in some way, let's say a gunshot wound or something, that we're fairly certain that this individual would have been harmed and would have needed medical attention. It's not uncommon for police to canvass an area and try to figure out which hospital they might have been to. So, I mean, asking whether an individual has been in the hospital is one question, but then confirming what type of treatment they may have received. Not actually seeing the medical records, but to see if that person was actually checked into the hospital and if they had received treatment at that time. So that would be, at this point, some of the information that we would require without actually getting the actual content of the records in order to carry forward the investigation.
Thank you for that, Sergeant Gilks. I guess I'm having a little bit of trouble with the idea that we shouldn't include this because there's sufficient supervision. You mentioned judge. Now, these will not just be issued by judges. They may be issued by justices of the peace who may have no legal training at all. So we could have a discussion about the level of supervision. But leaving that aside for a moment, we're always reviewing this after the fact. So whether it's a confirmation of service demand or the production order, it's always going to be an after the fact, was this done correctly? And if the information just violated solicitor-client privilege, that would be a basis to appeal that, I guess. But it's upfront to make that signal. And I want to also just provide another example, because in other circumstances, at least that I was able to find, this is specifically laid out in the legislation. So in the CSIS Act, for example, there's a specific provision with respect to orders that allow a judge to revoke or vary an order if they're satisfied that it would disclose information that's privileged. So that's same situation, production order, getting information, but it's right in black and white to make sure that it's clear that information subject to privilege should be protected. So if it can be, like, why include it in some here, like the CSIS Act, but not included in C-22 when we've already included it in another provision? Because I always look at an act and say, well, if Parliament says something in one section but doesn't say it in another section, that means something. So I would prefer to just be consistent. I think we all agree that, and I'm not going to talk about the medical information because I don't have enough knowledge right now to speak on that. But on the solicitor-client information, I don't think there would be disagreement that should be protected under these production orders or confirmation of service demand. I mean, the bill says it will be protected under the confirmation of service demand itself. So why not be consistent?
Thanks again for the question. I really don't think the bill is inconsistent. As I mentioned before, 487.0193 already exists in relation to that. I also mentioned that there's a special process that police have to follow if they're going to search a lawyer's office. And I don't think it's very common that lawyers' offices are served with production orders because of the reasons that we talked about, solicitor-client privilege. So there are a lot of protections already for the solicitor-client privilege in the criminal code. So if we're just focusing on that part of the amendment, I would say that it's completely redundant. Although it's not upfront in the provision itself, it's in a provision that applies to all production orders. So this provision, 47.0193, would apply to this new production order.
Fair enough. I thank you for your comments, Mr. Wong. I would just say I don't see harm in saying something for greater certainty that this is important, and we've done that in another section of the bill. You've provided your reasons why you think that is, but I think when you're dealing with something like solicitor-client privilege, which is at the top of the hierarchy of information that should be protected, and searching a lawyer's office, that's going to put it smack dab, in front of somebody. But solicitor-client privilege can be held in many, many different places. It doesn't mean you're just, searching my former law offices. So I would be much more comfortable if it was clear in C22 that solicitor-client privileged information is off limits for production orders. Thank you.
Thank you, MP Manteau. MP Housefather.
Thank you, Mr. Chair. I just wanted to, a lot has been said right now about solicitor-client privilege. Would I be correct in saying that the Supreme Court ruled in Lavallee that the name and address of a client is generally not covered by solicitor-client privilege?
Sorry, could you please repeat the question?
Would I be correct in saying that the Supreme Court ruled in Lavallee that name and address of a client is generally not covered by solicitor-client privilege? Like, for example, as I understand it, in R versus Budd, it was determined the identity of a client is not privileged unless that identity is critical to the essence of solicitor-client communications. You'd have to, the name, presumptively the name of a client is not privileged.
I think that's contextual, as you said, in terms of if the name of the client would reveal some aspect of that, then it may
be critical to the essence of solicitor-client communication. So what I'm asking is, in the context of the limited information that could come under such a production order, is that even possible, given what can be provided under this type of an order?
Not only would I say it's not possible, but in the scenarios that we've talked about, it would be, I think, impossible for police to determine from the outset whether or not it's going to involve that unless they were actually targeting a lawyer's office. And then there's lots of protections in the criminal law for that.
Thank you.
Thank you, MP Housefather. MP Lawton.
Thank you, Mr. Chair. I was hoping Mr. Housefather would continue for a few more moments so I could finish the paragraph in Lavallee. But one thing that is noting is that Lavallee is clear that identity can be. There is a clear statement in that ruling that there are cases where that is germane. So it isn't a blanket rule that the name of a client is not privileged. So we're talking about things that can be here. And I think when we're drafting legislation, when we're giving the government new powers, we have to think of edge cases. We have to think of areas that will push the boundaries because that's what prevents this from being unconstitutional legislation or constitutional legislation in a lot of cases. And we've certainly had at other committees discussions about the Supreme Court's own usage of hypotheticals to push those boundaries, even without a fact scenario requiring it. But I just want to return, and Mr. Mantle started off down this road. I want to return to this duplication because you seem to say, Mr. Wong, and I do not want to put words in your mouth, so please tell me if this is not the case, that if the existing for greater certainty clause in clause 31 sub 2, this is under confirmation of service demanded judicial control, and just for certainty of what I'm talking about, it says, for greater certainty, a demand must not be made if the confirmation would disclose medical information or information that is subject to solicitor-client privilege or the professional secrecy of advocates and notaries. Now, I'm going to read. That was in C22. And now we have Madame de Belfoy's amendment, which would insert in Clause 6, subsection 5, an order must not be made if executing it would disclose medical information or information that is subject to solicitor-client privilege or the professional secrecy of advocates and notaries. The substantive part of it is identically worded. The difference is in C22 where it appears, it talks about for greater certainty. But do I understand your earlier point, Mr. Wong, correctly, that in your opinion, if that clause in C-22 were not there, it would have no difference at all. The bill would be exactly the same.
Thank you for the question. Arguably, I think it would be the same without it because the confirmation of service demand now is limited only to telecommunications service providers. So I'm not aware of any lawyer's office or doctor's office that runs their own telecommunication service. So they're the only ones that can be served with a confirmation of service demand.
So why did the government direct the department to put that in the bill then?
I guess as sort of a belt and suspenders sort of thing, since that was such a public concern that this information might be disclosed. It's highly unlikely in the current drafting of the bill because of the limited scope of the confirmation of service demand. But there might be instances where there is a telco that knows for certain that what they're going to reveal, and I think Sergeant Gilks has talked about IP addresses being sold to other providers and then their services being sold, that it might end up being an online health sort of telco that might be fall under the definition, and that would preclude the confirmation of service demand being issued against them.
Thank you. Just, Mr. Chair, I don't have a full agenda of the names of the witnesses. Am I understanding correctly that the Liberal government has not made the Privacy Commissioner available to this committee as we engage in this work? For clause by clause?
My understanding is that Privacy Commissioner did come as a witness several weeks ago. He may not have been present, but he was there. And Madam Kirkland can testify to that.
Okay, but not for clause by clause. The Privacy Commissioner is not. The reason it's important is because the Privacy Commissioner was the. Oh.
Madame de Bellefeuille?
Oui, j'aimerais. Ms. de Bellefeuille, it's true that he came here to testify, but when he did, you might remember, he talked about submitting his document, and we didn't have that document of his on hand, and we didn't have his amendments, therefore, and he was speaking to us as if we did, but I might be confusing him with a different witness. Could you confirm that we did not have the document when the Privacy Commissioner was here and it had not been sent by the clerk at that time? Was that the document that the clerk had apologized for? I will have a look back into the minutes of those meetings, but what I do remember is that all submissions that came to the committee were translated, except for one or two that we only received a few days ago. But, Mr. Chair, says Ms. de Bellefeuille, I want to be clear. You said the Privacy Commissioner testified, and that is true. However, we were all surprised that when he did, we did not have his document on hand, translated. And that is an important nuance to point out. And if I'm remembering, and once again, I am not a lawyer or a notary, but I do have a generous memory, and I can tell you that that was the document that our clerk, and I hold nothing against him, had apologized for because he had forgotten to send it to us so that we could have it in front of our faces to be able to question the commissioner. And this is important, and I would like for Mr. Lawton to be aware of it because he might not have been there, but I was. Thank you very much. Inaudible for the interpreter. You will have the confirmation, Ms. de Bellefeuille, of exactly what happened, and we will be able to verify that with the clerk. Ms. Dandurand. In general, I trust Ms. de Bellefeuille's word, who has an exceptional memory and who is familiar with what happened. I think that was what happened, because I think it was the end of May when the commissioner testified, and we had received his brief several weeks prior. Very well. Ms. Dandurand, your memory is not too shabby either. Mr. Au.
Mr. Chair, I think instead of, relying on memories, shall we find out from the minutes what had already been submitted at the time? So before we go on, because otherwise, we are based on memories, which could be faulty. So may I suggest that we pause and find out from the minutes?
Good, and that's what we'll do. And as the analysts and others do that behind the scene and behind the screen, let me turn back to MP Lawton for any additional input.
Merci, Monsieur le Président.
Thank you, Mr. Chair. That was a good question from my colleague, Ms. de Bellefeuille. And I believe that the amendment was suggested by Mr. Dufresne.
Valuable to have had the commissioner testifying about the amendments that were very important to protect the privacy rights of Canadians. And I know that this was something my colleagues attempted multiple times to have happen, and it's unfortunate that the Liberal government did not want to do that and has now actually introduced legislation that further weakens the power of the privacy commissioner, which is seems to be adding insult to injury for someone that's trying to help Canadians here. But in any event, I appreciate that very much, and I would just submit to this committee that if the government felt it suitable to make crystal clear in the statute that medical information and solicitor-client privilege was not going to be at issue in the confirmation of service, which again is actually a lot harder to draw a line from confirmation of service to medical information or solicitor-client privilege. So if that was the argument from the government in that section, I see no reason why they would not want to make the same crystal clarity in the actual production component, where there is potentially a greater connection between these two things, unless, as Mr. Mantle suggested, it was a deliberate reason to not offer that certainty and not offer that assurance. And, the government has had months to work on this bill. You have to assume that everything in it is deliberate, just as you have to assume everything not in it is deliberate. And that speaks to the broader point of why cutting short this committee's process, preventing us from being able to sub-amend amendments, is an incredible violation of the rights and privileges of members. Thank you.
Deputy Mantle, do you want to intervene again? Yes, please go.
I'm not even clipping. I'm just on my own time. I'm serving Canadians, Seema. It's okay. We're working for the people.
Thank you, Mr. Chair. I just also want to comment. I think I heard Mr. Housefather say that some of the information in the subscriber production order was minimally identifying or narrow, and I take a very different view. I think we've established that the confirmation of service is certainly much less intrusive, but the subscriber information is quite broad, and it goes beyond just the potential to identify a name or an identifier of a person. So I'm not sure I agree with his point that there's no likelihood that that might be disclosed in this. I mean, it includes all the types of services provided, or could include all the types of services provided, when those services have been provided, and anything that identifies devices, equipments, etc. So I just want to put that on the record. I think that's take a different view on the scope and how broad the production order for subscriber information is. Secondly, I will reiterate, it would be fabulous and useful to the committee to have the Privacy Commissioner here to actually speak on his suggested amendments. And I know we have asked for unanimous consent multiple times, so I'm not going to do it again, because it will be futile with the members across the way to get consent to bring the Privacy Commissioner here. This is an example of how this process has become fouled by the members opposite, who simply don't want to have and devote the sufficient time to going through this bill in a civil and substantive way to deal with these issues. And so they may not like being reminded of those decisions, but we will continue reminding them of those decisions. Thank you.
Thank you, MP Mantle. MP Kirkland?
Thank you, Chair. I just want to take a moment to defend the honor of my colleague, Mr. Lawton. It seemed like there was a lot of anger sort of thrusted toward him just now when he said, we really want the ability to possibly add sub-amendments to amendments. And if the Liberals get their way and they choose to follow through on a programming motion, the truth is that not only will we not get to look at each amendment and possibly suggest sub-amendments, but we also will be hiding that from Canadians because they will be deemed moved. And Canadians will not be able to see what the amendments are until they've already been voted on. They will not be able to give their opinion or give their thoughts. So I would just ask, that we consider that, and I urge the government of the Liberal government, based on this information, that we want to be able to move forward and have good amendments in this, and I can assure law enforcement as well that we want to give you the tools that you need. But we need to do this right, and voting without the ability of adding sub-amendments or voting on amendments without the Canadian public knowing even what they are, they don't get to see them if they are deemed moved. We don't get to read them, and the public doesn't get to see them until after they're voted on. So I just want that very clear and on the record. And that's all I'll say on this point. Thank you.
Merci, Madame Kirk.
Thank you, Ms. Kirkland. Mr. Housefather.
Mr. Chair, that would have been very reasonable. In my knowledge, Mr. Chair, having been here now 10 years, you normally can get through somewhere between 6 and 7 amendments an hour in a clause by clause. Right now, we've been going for, since 3:30, we've gotten through one vote. And that's only happens if people procedurally block us from actually doing our work. And that seems to be what's been happening today, where the Conservatives are desperate to not vote on anything, desperate to ask anything about everything that has nothing to do with the amendment at hand, and they don't want us to move forward. Correct. And then you have no choice but to do a programming motion. We have 4, and if I see in the next hour we get through 6 amendments, then I see we're starting to work. But so far, the last several meetings, Mr. Chair, we haven't done any of that.
Thank you, MP Housefather. MP Kirkland?
Thank you. Because you said that, I feel like I need to respond. I will respectfully disagree. We are trying to move through these. We've had legitimate questions. Every question has been legitimate. In fact, I think we're just about ready to move on this one. But the truth is, we wouldn't need to spend so much time asking questions on the amendment and the bill had we had enough study before clause by clause to be able to fully study the bill and understand it. For instance, when the Privacy Commissioner was here, there were only 2 rounds of questions. We couldn't even ask him about his suggested amendments because we didn't have them yet, as Madame de Belfoy said, and that is the issue I take, and which is why, last week I suggested simply, could we please have consent to have the Privacy Commissioner here? Liberals blocked that, as they have been doing. So we've been trying to move, and Liberals have been blocking the movement that we've been trying to make. But I do want to leave it at that, because I genuinely would like to see us move forward on some amendments, and that is the truth. So despite the arguments happening across the table, I think that we can move on, and we can ask some excellent questions, as my colleagues have been asking tonight. Thank you.
Merci, Madame Kirkland. Monsieur le député Mantle.
Thank you, Ms. Kirkland. Mr. Mantle.
Mr. Chair, I will disagree with my colleague, Mr. Housefather. I mean, all of the questions that I've asked this evening have been directly on point, and in fact, all of the questions I've asked at this committee have been directly on point. And I would stand by that, and we can go through the transcript and together look at that. But that is because I'm trying to understand a complicated bill that has sweeping repercussions for Canadians, for our security interests, and for our privacy interests. And there's no magic formula for how many clauses should or shouldn't get passed in a set amount of time. It's contextual. It depends on the complexity of the clause, the complexity of the bill, how it interacts with other clauses. So I don't think that's a fair assessment to just draw a blanket generalization about how many clauses should or shouldn't be done. And it sounded to me like the programming motion was being used as a cudgel or blackmail, that if the government sees that this is moving to their liking.
Monsieur le député Mantle, apparemment qu'il y aura des...
Mr. Mantle, it appears there's an interpretation issue. Let's try and check.
Speak in my broken English to see whether interpretation is working. Merci, Madame la députée.
Thank you, Ms. de Bellefeuille, for having raised the issue. Microphone, please.
Listen to you more often, MP May, but unfortunately, fortunately, we'll return back to Ms. MP Mantle.
Thank you, Mr. Chair. Always good to have some levity at the table. Good reminder for myself included. But to begin my thought again, it sounded to me like Mr. Housefather was suggesting, and he can go on and clarify in his own words, that if the government is seeing progress, whatever that may be, to their liking, that programming would not be necessary. That seems to me like blackmail rather than civilly and substantively engaging in the content of this bill, giving it the appropriate time and consideration that it requires. It is certainly not the fault of the opposition that this government waited 10, 11 years to bring forward lawful access legislation, and then in the last week of Parliament decides to try and ram it through the House. I mean, so I will respectfully disagree that the programming motion, is a necessity at this part in the government. It is not. They've had sufficient time to do this, and we're going to ask the questions that we need to ask so that me as a voting member, I am comfortable with whichever way I decide to vote on this bill.
Merci, Monsieur le Député Housefather.
Thank you, Mr. Housefather.
Chair, I'll just leave it at the word blackmail, of course, is completely offensive, and it would be like me saying when the Conservatives said that they would allow the Part 1 of the bill to go forward as long as we split the bill and not have Part 2, then things would move forward, and that would be, whoa. Under Mr. Mentel's words, blackmail. I would never call it that. He would. So, Mr. Chair, all I could say is I've been here for 10 years. I know when people are genuinely trying to move forward with a bill and asking pertinent questions. I watched Mr. Mentel last meeting spend an hour on a very simple amendment asking exactly the same question over and over and over and over to the point that it was repetitive to the ninth degree. And it seems clear to me that, unfortunately, we could have, starting at 3:30, gone through 20 amendments by now. We haven't. And that would have been at a slow pace. Certainly, some are going to be more complex than others. But this is not any effort to make it through clause by clause in good faith. Thank you, Mr. Chair.
Thank you, Mr. MP Housefather. Est-ce que l'amendement BQ6...
Is the amendment BQ6 carried?
Vote par appel nominal.
We will proceed to a recorded division. Mr. Clerk, please.
On the amendment for BQ6, Mr. Ramsey.
Contre.
Mr. Housefather.
Contre.
Mr. Pulaski.
Against.
Ms. Akan.
No.
Madame Danderand.
Contre.
Ms. Sodi.
No.
Mr. Mantle.
Yes.
Mr. Lawton.
Pour.
Ms. Kirkland.
Yes.
Mr. Au.
Yes.
Madame de Bellefeuille.
Pour.
Non, 6, 8, 5.
Merci, Monsieur le Greffier. L'amendement...
Thank you, Mr. Clerk. The amendment is defeated. Is Clause 6 adopted? As amended? Yes. Does Clause 6 carry? On division?
Recorded division, please.
Avec un vote par appel nominal.
With a recorded division, if you please, Mr. Clerk.
Oui. Article 6, oui, n'est-ce pas? D'accord. On clause 6, Mr. Ramsey.
Pour.
Mr. Housefather.
Yes.
Mr. Pulaski.
For.
Ms. Akan.
Yes.
Madame Danderand.
Oui.
Ms. Sodi.
Yes.
Mr. Caputo. Correction. Mr. Mantle.
No.
Mr. Lawton.
No.
Ms. Kirkland.
Yes.
Mr. Au.
Oppose.
Madame de Bellefeuille.
Contre.
Oui, 7, non, 4.
L'article 6 est donc adopté.
Clause 6 carries. We'll move to Clause 7. Ms. de Bellefeuille, do you wish to move Amendment BQ7? Yes, Mr. Chair. The amendment being moved was inspired from a recommendation by the Quebec Bar, which once again finds that the threshold for intelligence is too low and wants to raise that threshold and change the wording to reasonable grounds to believe rather than reasonable grounds to suspect. Once again, I would like to seek justifications because we were talking about the beginning of the investigation. Could you please continue to shed some light on this for me and provide some examples for me? I imagine you would be against this amendment. Before allowing the officials to answer, I would like to mention that since BQ7 has been proposed, NDP 5 and CPC 5 cannot be moved because they are identical to Amendment BQ7. Over to you.
Merci de votre question.
Thank you for your question, Mr. Chair. As it pertains to us, the police, there are companies that are inside of Canada and companies that are outside of Canada, and the services provided, chat apps, for lack of a better term, can come from the United States or even from other countries and can be very popular here in Canada as well. And they are often used either to communicate with other individuals who may be involved in the crime or other individuals who have committed offenses under the criminal code. There's no difference between use of an application that is based here in Canada versus one that is based in the United States. So here we are talking about the early stages of the investigation. For example, if we receive a complaint and the mode of communication was via an application for which the company is based outside of Canada, we are at the beginning stages of the investigation and we have to seek out the same types of information regarding the crime, an individual, or a device, and so forth. Ms. de Bellefeuille. Mr. Chair, so at that stage of the investigation, do you know the name of the individual and the device? Could you clarify? Because earlier I rather agreed with you when you were answering me, and we were asking about whether an individual was provided a service by a company. But can you specify what stage of the investigation you're in? Is this the stage where you have the name and the device? Answer. Sometimes we have neither the name of the individual nor the device. If the individual was contacted via a platform, we may only see the number associated to that service. For example, it could be a phone number or a number associated with an account. So that means all that we have at that stage is a number associated with an account that contacted our victim. So we might see messages or images. In order to find out who sent that information, we need to determine which individual is associated with that account and perhaps where their location is and perhaps which other services are being provided to them. Ms. de Bellefeuille. Let's take, for example, if an image is sent, a pornographic image or an image that is not okay to send, it seems very obvious that you would move to the next stage. If you receive a message describing a pornographic scene, you really have reasonable grounds to believe that, given the nature of the photo, it's very obvious that there's either human trafficking or there is child pornography occurring or there is non-consensual use of a sexual image. Could you comment on that? Answer. Depending on what we receive as a statement, it is possible that given the nature of the image, an offense has been committed. A microphone, please. So a crime may have been committed or may continue to be committed. You gave me that type of image as an example, and I didn't find it was the best example, because if there's a compromising image, then you have reasonable grounds to believe and not just to suspect. Answer. Well, it depends on the type of image you receive. It might be an image, for example, as you mentioned, where it is child pornography. And yes, you're correct. That would be a clear case. But it could also be an image where the crime is a crime of extortion. And it could be a trivial image for just anyone else, but for this individual, it is a crime. Then it's more difficult to determine if it's really a crime, because there could also be a message sent with no image attached. It can be difficult to determine what the objective behind sending that message is. We have to establish mens rea, which is the intent to commit an offense. Ms. de Bellefeuille. And if we were to raise the threshold to obtain the information, you're telling us that we are depriving you of being able to carry on your investigation. And you say that even when the wording is reasonable grounds to believe, you're not 100% certain of being able to continue. So if you were to take the lower threshold, what would it allow you to do in addition to what you already can? Can you comment on that lower threshold? Because there might be dangers associated with it if more information is allowed to be requested. Answer. The type of information that we are allowed to request is limited under a general production order, even regarding the content of communications. Your colleague mentioned something earlier. There is an increasing complexity and also volume of crimes associated with online devices and use of the internet. So because of this complexity and volume, a tool is needed to sort the crimes that occur and, as quickly as possible, to identify either the suspects or eliminate suspects or link individuals to other crimes that have transpired in other locations in the country. Ms. de Bellefeuille, thank you very much for those specifications. Mr. Chair, I don't want to take more time, but you have been expressing a feeling that I have had. When the minister told us that the minister was open to amendments, and we're only so far as Amendment 7 so far, or Clause 7 so far, one amendment has been sub-amended by the Liberals, and none of the others have been carried, except for that one which was changed. But your comments are hitting home for me, because our committee has devolved into a farce, and we were, I would almost say, an exemplary committee. We went through C8, we went through C12, we reached agreements. And why were we able to reach agreements? Is because there was an exchange, a true exchange and collaboration. Mr. Housefather can complain all he likes, so can Mr. Ramsey. They can make as many sub-amendments as they like, but at the end of the day, they know that they are going to vote against the amendments. They already know it out of the gate, and I understand that they don't want to sit until midnight, but here's what it means to me. I'm here to understand the amendments that I've made, and I'm here to try and better understand this bill, even if we have to sit until midnight. So I don't like to be accused of slowing down deliberations. What bothers me is that no matter what I say and no matter what the answers are from our experts, the Liberals' mind is already made up, and no matter what we do, by Friday the bill will be carried. And I'm disappointed that the minister, who really did appear to be open to our contributions, it doesn't seem to be the case. And I understand that our Liberal colleagues are impatient, but by Friday, the bill will be adopted. But in the meantime, we should not be criticized for asking questions because it is our right, and that's all we have left. So I would like to make that very clear. We might sit until midnight tonight. They might like for us to get through things really quickly, but by Thursday, we will get through the bill. And I would ask our Liberal colleagues to put themselves in our shoes, because no matter what our contribution is, it is not being taken into account whatsoever. And I wish to state this publicly because I put my trust in the minister's openness, but it did not turn out to be the case. So thank you very much. I found you very adept at explaining the answers to me. And I would say that I am very torn because I trust the Quebec bar, and I'm having trouble understanding where the line is. I'm wondering, is it really that bad for you not to have a different threshold? I would be really reassured if I saw the government doing its part as well, because there still are doubts around this bill. I would like to see the government doing work as it needs to be done, because there were documents that we did not receive. We received 160 letters. I read many of them. Many of them are very valid. I would like to hear the architects of software. I don't know, Mr. Bilodeau, if you know about software, but I still have questions on these topics, and I'm not filibustering. I'm not asking questions for no good reason. The government is all ready. They know what's going to happen, and you, the witnesses, I find you extraordinary. I commend your patience, but I would have liked for you to see a better model, a better example set by the government opposite. And you are showing professional rigor. And I would like to state that if we're asking you questions, it's because we're interested, and we should be interested. And when we still have questions that haven't been answered, we do have to sit until midnight, because come Thursday, all we're going to have to vote is yes or no. And to me, that feels like we can't even contribute because the government is stopping us from doing so. There's no compromise. There's no negotiation. So that's what I would like to say. I won't repeat myself, and I won't hear anyone else on this committee tell me that I am off topic or filibustering. But that is where I stand, and I found it very important to state it for you. This is not how we should be working on a bill that changes our culture. It changes protections around privacy. And that is what I had to say. And Mr. Chair, now that I have said it, I will conclude regarding BQ7. Thank you, Ms. de Bellefeuille. Very well said, very duly noted. Mr. Ramsey. If we voted for BQ7, here's what would happen. We would end up in a bizarre situation where we would be asking less of a foreign entity or rather, the threshold for asking for information from a foreign entity would be higher than the threshold for asking for information from our own Canadian entities, such as companies here in Canada. So to my mind, that seems illogical because we should have the same threshold for companies here in Canada versus the United States. Am I mistaken? Answer. Thank you for the question. I will answer in English.
You are correct. The way that the tool is designed, this is the international production request. It is a non-compellable, judicially authorized request. It's not an order, but it's based on the underlying information that police can obtain in Canada, which is the subscriber information that we just finished talking about and the existing transmission data production order. So if police can meet the threshold for those tools, they can also ask a judge to issue a request that can be served on a foreign entity to provide that information. So you are correct that if this amendment, this motion, were allowed to pass, it would make it more difficult for police to get information from foreign service providers than for domestic ones, and it would arguably make their current situation worse.
Monsieur le Président, sur la base de...
Mr. Chair, given that confirmation, we will vote against this amendment. I would just like to come back to a few of the comments that were made. I think that there is no party around this table that has collaborated on this bill more than our party. So Ms. de Bellefeuille is free to think what she will, Mr. Lawton as well. But I maintain, and I'm very deeply proud to say that our party has fully collaborated on the deliberations here. And if the circumstances led us to act any other way, I don't think that those comments apply to us. That's all I have to say. Thank you, Mr. Ramsey, Mr. Lawton, then Mr. Au, and Ms. Cronus. Mr. Lawton to begin.
Mr. Chair, before I get into the substantive points and questions for officials on the amendment, I have to respond to the rather bizarre straw man argument we just heard from Monsieur Ramsey. He says that because the Liberals voted against a previous amendment that would have made the bill better, we can't support this amendment because it would lead to an inconsistency between the two. The problem there, as is glaring to people certainly on this side of the table, and potentially that side, given that Ms. May has the fortune of sitting in the government bench right now, is that the Liberals are basically saying because they made a bad decision earlier, we now need to, in the interest of consistency, stick to that. Now, I think it's a bad decision. They obviously disagree with that point. But the evidentiary standard, the standard of proof that we're seeking here in Part 1 of the bill is incredibly germane, and it actually is one of the areas where I had hoped at the outset of this we would have collaboration across the aisle, but there has been no collaboration from the Liberals on Bill C-22 in general. We've seen minimal, if any, collaboration on the Part 1, where I think there's actually significantly less daylight between us. And I would note that we have repeatedly made the offer to pass Part 1, which is consistent with the authorities that the police I've been speaking to in St. Thomas, in London, police chiefs in other parts of the country, the powers that they are actually asking for. And this idea that Part 1 cannot exist without Part 2 is entirely false. And if so, that actually means that perhaps there are more problems with Part 1 than people have realized. But I think Part 1 stands on its own and deals with the need to have expeditious production orders. I think confirmation of service is incredibly reasonable when I hear the time delays that police on the ground often encounter trying to find information to seek what would go into a production order. But, you know, we already have from our officials here a pretty important recognition that this is fundamentally a different mechanism than the one that exists for domestic service providers. This is a request and not an order. So I don't know if this would go to our law enforcement officials. I think it probably should to start, but anyone can feel free to add in. What is the current process? Because we have to situate this amendment into the broader context of the clause itself. What is the current process for accessing this information from a foreign telecom provider? And what would it be if Clause 7 unamended were adopted?
Thank you for your question, Mr. Chair. So essentially, it really depends on which province you happen to be in. So there are some providers in extra-jurisdictional or providers from outside of Canada, which will accept a production order from Canada. That being said, depending on the province that you're in, a justice or a or a judge may not actually sign your production order because they do not believe that they have the jurisdiction to order a company outside of Canada to actually action whatever the order is. Short of that, the alternative would be the mutual legal assistance process, and that is it takes considerable amounts of time, resources in order to actually get that completed. And then the response time could be, you're looking at it maybe 6 months, a year, something like that, really depending.
If I could just pause there for a moment, please, Sergeant. Just to understand what we're talking about here, is this an American Verizon customer who is in Canada and an investigation leads you to this person who is in Canada physically or was in Canada physically and you're trying to get the information from Verizon? Or is this, in the course of your investigation, you find that someone in Canada was in communication with someone in another country and you're going to get information from that person, or do both situations fall into this?
I suppose both situations could fall into it if the provider holding that data is situated outside of Canada. Now, regardless of how they, it actually depends on how they actually perceive themselves, as whether they do have some sort of presence in Canada and they're willing to accept that a judicial authorization, a Canadian judicial authorization, or they may say that they are exclusively outside of Canada, and you'll have to go the route of a mutual legal assistance treaty.
And just building off of that point, if we are talking about, I don't want to single out Verizon for no reason. If we're talking about someone who uses T-Mobile and they're in Canada, when they're in Canada, they're actually on a Canadian network. They're on a Rogers or TELUS or Bell. In situations like those, are we talking about domestic capabilities or foreign service capabilities for how your investigation would have to go after the information?
Sorry, that's an excellent question, and that's one of the challenges that we face as police, because we, depending on the type of crime that has happened, we have to establish what type of evidence actually exists, where it might actually exist, and then find out what type of judicial authorization is required to actually go and collect it. Now, there's a lot of challenges based on the type of technology being used, how that communication may be routed from one point to the next, which may affect where that information that we're actually required is being held. In this particular case, we're talking about something like subscriber information. Subscriber information is generally only held by the company offering those services directly to the client, and not by another company where traffic may be routed through, for example.
That's very helpful. So when you're getting this information now under the current system, is it completely ad hoc? You could one day have success with one company in one country and another day not, or are there existing channels either through Interpol or agreements between Canada and other countries, or between police agencies in Canada and police agencies in other countries?
It really depends on the entities themselves and also the nature of the investigation. There's different types of parallel investigations, joint investigations, which can be conducted with police agencies from outside of Canada, and that might change the dynamics on how that information is actually recovered. But unfortunately, it's kind of it depends.
Yeah, I understand. And I'm trying to come up with all the different scenarios here that we need to envision. So when you run up against roadblocks, when you're trying to get access to information that is in the possession of a foreign country, are you generally getting hung up on the company's policy or the laws of the country in which that company is occupied? Which is the hammer that comes down and says this information can't be turned over to you?
That's an excellent question. I'm not sure we always have the details as to why the production order is refused. And honestly, they don't really need to provide us with an answer as to why. It could simply be no. We are not a Canadian-based company, therefore we do not honor this production order.
Thank you. And the reason I ask is because I do think there would be an argument, and I'm talking specifically about common law countries, developed democratic countries with robust rule of law systems, that if they look at our laws and see that we actually have a lower standard of proof than they would have in similar circumstances, that would be a pretty significant reason by which they would say, well, actually, Canada has such a low standard to qualify for a production order that it actually doesn't meet our needs. And we may end up, and again, I haven't done a comparative analysis on, similar systems. We often hear from the Liberal government that Canada is supposedly a late adopter to lawful access. So I think it would be an important discussion in harmonizing the standard that we have in our laws versus others. Does anyone have a comparative analysis on how other countries around the world, either Five Eyes or similar nations, treat the evidentiary standard, looking at, I guess, common law countries?
Thank you for the question. We do have a comparative standard, and Canada, by far, has the most robust privacy protections. The type of information that we're talking about, transmission data and subscriber information, is obtained without any judicial oversight. In many countries, police are authorized to ask for this information directly. In other countries, prosecutorial magistrate, which is like a DA. In the United States, it's an administrative subpoena that's issued by a DA. So in terms of if you want a comparator, the fact that we need judicial authorization is something that other countries don't require.
I mean, look, it's been pointed out by a number of privacy experts that, some of what's in this bill is actually more expansive even than the United States Patriot Act. I get the sense you would disagree with that point. But not even just looking at robust privacy protections, because other countries have very strong privacy protections in their constitution and other laws. I'm talking purely on that evidentiary standard. Have you done a comparison on the standard of proof in other countries in their production orders?
Yes.
Okay. And would you be able to provide I guess it's a little late to provide it in writing, but what are the comparison points there among Five Eyes countries?
As I mentioned, because some of it's statutory, it could just be relevant to the investigation. So it's a subjective test done by the DA or the police officer, whether or not they need it for their investigation.
So this is, I think, why we had to question so much the earlier amendment from Madame de Bellefoy, which, again, I think it's regrettable the Liberals did not pass, because now we have the Liberals saying that because we didn't vote for that, we shouldn't vote for this, when I'd say, as I was told growing up, it's never too late to correct a mistake. And, I think that one of the reasons that it's so important is because there actually is some disagreement among legal scholars in Canada, and actually, if you look in case law, there's some disagreement among judges on what the evidentiary standards actually mean. And there was an essay to this effect. I forget where it was published, but it was by Terry Skolnick, who's quite renowned. I think it was in the Ottawa Law Review, in which he actually talked about what he feels as some of the shortcomings of the existing system and the distinction between reasonable suspicion and reasonable grounds to believe. And what the author had put forward as a novel way to reconsider or reimagine this, I thought was quite interesting. I won't get too much into the academics of it, but there was a crucial point that's germane to the amendment put forward by Madame de Bellefoy here, which is that in identifying new police powers, this is quoting directly from the Law Review article, and this is what Bill C-22 does. In identifying new police powers, courts should avoid imposing the standard of reasonable grounds to believe where the police power is minimally intrusive, briefly executed, highly accurate, and undertaken for sufficiently important law enforcement objectives. So the inverse is then true, that when a situation is not like that, when we have police powers that are not minimally intrusive, that are not briefly executed, that are not highly accurate, then we should not allow that different evidentiary standard to hold. And I think that's important because one of the things we've been seeing in all of this is that this is not limited. This is not minimally impairing. It's not minimally intrusive. The powers in here are incredibly broad, so we have to err on the side of privacy. We have to err on the side of protecting the fundamental rights of Canadians, the rights to be free from search and seizure, especially keeping in mind the nature that these applications are all done ex parte. These are all done without the opportunity for the person who's being targeted by one of these orders to go and make submissions to defend their case, to go to the previous amendment to assert that maybe they have solicitor-client privilege that would be at issue. So all of this is being done after the fact, after a potential breach has already taken place, after someone's rights have already been violated. So these are incredibly reasonable, common sense proposals. And I say this having had some spirited discussions with my colleagues from the Bloc Québécois. We disagree on a range of issues. But when we are in alignment and we have our colleague from the Green Party, our colleagues from the NDP, when members representing all the parties in the House but one from all sides of the political spectrum and no sides of the conventional political spectrum are all saying the same thing. I think it would be incumbent on the Liberal government to listen to this incredibly reasonable approach. And I have yet to hear from one single member of the government what would necessitate having the lower standard, what the one case is that they fear would not be captured by the lower standard that would be captured by the higher standard. And so far, they've not been able to do that. And I don't see any hands shooting up, but I welcome any hands shooting up there. I think it's the government defaulting to its standard position of wanting maximum authority and maximum latitude to heck with the consequences. Thank you, Mr. Chair.
Thank you, Mr. Lawton. MP Al?
Before I go on, I just want to applaud Madam Debbie Lafay for her remarks. I think she is right that as representative of the people, it's our duty to ask questions to make sure that we understand 100% what the bill before us would imply and to defend the constitutional rights of Canadians for privacy. And I also applaud her for pointing out that the Quebec Bar Association has made a very strong case opposing the changes. And I would argue that, it's something I don't understand. Why would the government would just dismiss those professional bodies for their opinion and recommendations? Basically, I think that tells me the government does not take those comments seriously. The government feels that they know best. The government feel that they can do whatever they can, and they were trying to get the most power they want to have. Now, I actually know my colleague, Mr. Lawton, has asked some of my questions for international comparison. And in particular, I just want to ask that, because we are not talking about general thresholds, we are talking about lowering the thresholds from reasonable grounds to believe to reasonable grounds to suspect in ordinary criminal investigations in order to obtain subscriber information or comparable digital personal information. So my question is, so can the government identify more specifically the countries that you have studied and the comparisons that you have made and the conclusion that you have come forward. Now, you generally said that we have to do a comparison, but again, I hope that I can get more information, more concrete information. And in particular, I want you to address one question. I suppose that in those countries, as you mentioned...
I'm sorry to interrupt. That's very rude of me, but I see the bells ringing, so I therefore would like you to continue. But for that to happen, we need unanimous consent. Yes. Is there unanimous consent on everyone's part? No. So we'll have to suspend and interrupt abruptly. MP Ao, sorry for that.
Welcome back to our meeting. We are still at BQ7, MP Hour.
Good. Thank you, Mr. Chair. I just want to follow up from where I stopped. And as I mentioned, I'm continuing the line of questions as proposed by MP Lawton. So there's talks about comparison, international comparisons, whether or not there are similar approaches to the threshold of, obtaining the permission. Now, I said before the break that I would like to have more concrete examples instead of a general description saying that, oh, they were similar jurisdictions using similar thresholds, and generally speaking, they're even more, kind of worse than us. So can I have more concrete examples, like, what countries and what kind of regulations that they may have? And in particular, I want to ask the question, how have they dealt with privacy challenges in court? So I suppose that in those countries, if they have similar thresholds as we are proposing, there could have been constitutional challenges or court challenges. So how have they dealt with those challenges?
I'll start the answer to that question. If it assists the committee, just maybe a reminder that I think one of our undertakings was to provide a comparison chart. So I don't know whether you have that, sir. But what it did is it looked at some of the 5 I's just in terms of trying to set out for you, comparing both the confirmation of service demand as well as the subscriber production order. And so you might recall that the other countries do not have judicial authorization. So there's no judicial oversight in general speaking. So there's no comparator. Like they don't need to set out to a judge or a justice that standard. It is simply either the agency themselves or the police officer themselves that would be making those demands. And again, just a reminder, if we take a step further back in time, pre-Spencer, that was sort of the world we lived in, right? So officers would go to service providers and ask and receive that information. So that's kind of what's happening with the 5 I's. And now, post-Spencer, police have been asking for that authority. And so what we've put before you is that new tool to make sure that there is judicial oversight for those sorts of orders. And so that's why we're talking about standards, but it doesn't exist. There's no real comparator internationally because it's not required by those countries, by the 5 I countries.
Can anybody supply more information?
I was just going to say that in terms of, to Kimberly's point, I think the debate about whether basic subscriber information needs to go to court for a determination about whether it should or shouldn't be granted isn't a thing. So in terms of level of robustness, we are at a starting point significantly higher, which again, for law enforcement, this specific amendment doesn't touch on CSIS equities, but generally speaking, we are on a different playing field. And so from an investigative perspective, that's, I think, the case we're making here is that we need to have a tool that's agile, usable, and also stacks up well to partners. And I think it would be our supposition that what we've put in front of you does those things.
So in other words, we're breaking into new grounds. We are doing the experiment, and we do not know what the end result yet. Is it fair to say that?
For Canada, we're breaking new ground, but actually it's ground that's well trodden, I would say, by similar countries to ours, and all of them are doing this at a lower threshold than we are talking about here, and significantly so, I would say. So.
Okay, great. Thank you very much. So now I want to turn from international to domestic, and it's just mentioned about Spencer, right? And again, I'm not a lawyer. I'm trying to educate myself through studying some of the cases, and through my research, of course, the case of Spencer came up. But I tend to feel that we may have come to a different conclusion. Now, in the Spencer case, as I found out, the police was investigating the sharing of child pornography over the internet. Then the police obtained an IP address and then asked the service provider for the subscriber's name and address without a warrant. So I think that was the case, right? You have that correct, sir. Yes. And then I think through the court hearing, a key question was asked, which is, does a person have a reasonable expectation of privacy in the subscriber's information linking an IP address to their identity? And I think the Supreme Court's ruling is yes, right? The Supreme Court felt that there should be a reasonable expectation of privacy for the subscriber information.
Again, you have that right, sir, because before that, there was case law that said sort of basic subscriber information did not even engage Section 8. There was no reasonable expectation of privacy. So this was quite new, and you're right, that's what the court held. Okay. And that they required a judicial authorization, which is what's before you now.
Right, exactly. So as you said, the court went on to say that the subscriber information is not merely a person's name and address, and when linked to an IP address, it reveals who was using the internet connections and therefore provides the key to uncovering persons' online activities and so on. But I think what the court rule, the ruling was that, the court said that instead of lowering the threshold, perhaps it's just the opposite. It should be better protected, and the case established subscriber information and just conditional privacy protection. So I think that's the first case. And then, of course, I found another case in 2024. I'm not sure it's pronounced it right, by Kovacs case. I think, again, you know about the case. And I think the court went on to 10 years later, after the Spencer case. I think the court asked another question related to the new technology. So the question asked was, is there a reasonable expectation of privacy in an IP address itself? And again, the Supreme Court's ruling is yes. So the court also went on to say that the modern internet use leaves detailed digital traces. Once an IP address is linked to other information, it can reveal a lengthy, detailed picture of an individual's activities. So accordingly, the court mentioned that technological developments should have greatly increased the amount of personal information that can be inferred from digital identifiers. So rather than reducing privacy protection because of technology makes surveillance easier, the court held that constitutional protections must adapt to preserve meaningful privacy in the digital age. So putting all this together, my question is, now the Supreme Court has made it clear that subscriber information and IP addresses reveal far more than technical data. It's not a phone book information anymore. They can expose a detailed portrait of a person's private life. If the court has recognized increasing privacy interest in digital information, what evidence do you have to conclude that reducing the legal threshold from reasonable grounds to believe to reasonable grounds to suspect is consistent with Section 8 of the Charter?
Thank you, Mr. Chair, for the question. I'm going to start by just sort of situating you with Section 8 of the Charter. So it permits reasonable searches and seizures in recognition that the state's legitimate interest in advancing enforcement goals remain consistent with privacy. So it's a balancing exercise. So it's a two-part test. The first one, was there a search at all? So was there a reasonable expectation of privacy? Because it's not complete privacy, it has to be a reasonable expectation of privacy. So the Spencer and Bajkowicz was in the first part. Was there a search at all? Because before that, the case law was there wasn't even a search. So the minimal intrusion, there was no reasonable expectation of privacy. The court is saying now there is, folks. So you need to go to the next stage, which is it authorized by law? Is the law itself reasonable? And was the search conducted? So we're in a new world, which we need the tool to be authorized by law. And so in constructing this piece of legislation for your consideration, that's what we did, is we said, okay, it has to be judicially authorized, and we're looking for a tool that's useful to officers because we already have all sorts of hammers, as it were, in the search world. But we need something tailored for officers to use at the beginning of an investigation where we're not looking for evidence of an offense. We're actually just looking for information. And so it's going to be tailored. It's got to be narrow. It's going to be judicially authorized. And so in that balancing, in that weighing, the reasonable grounds to suspect, which is used in all sorts of situations where things are tailored, where the intrusion is minimal. That is the standard that's used in criminal law. So that's why that is put before you. There is no lowering. Nothing's been lowered because this is a new tool. And so I hope that answers your question, but I just want to sort of situate you in terms of Section 8 more generally?
Well, not quite, because even though you said that it's not lowering the threshold, but in fact it is, right? You're making a distinction between reasonable ground to suspect and reasonable ground to believe. So you have make that kind of distinction. And at the end, you're choosing the lower one, the lower threshold, which is to suspect rather than to believe. So actually, you do lower the threshold. So are you saying that you don't expect there will be some constitutional challenge if this threshold is being adopted?
So, again, just to make sure that we're on the same page, right? So in before Spencer, 2014, officers routinely received this information voluntarily. Spencer changed the world, and the Supreme Court of Canada said, you need lawful authority. They didn't say you need to get a warrant that's at the reasonable grounds standard. They said you need to create a law that allows officers to have this power. And so in crafting the legislation that's before you, we looked at criminal law more generally, the criminal code, and then the nature of the intrusion itself, the tool itself. And so it is tailored. It is limited in scope and nature to such an extent that the reasonable grounds to suspect standard was chosen for that new tool. But it is consistent with the criminal code and other provisions like it. So there is, it is consistent is what I'm trying to say.
So do you anticipate that this will be challenged in court?
What I can say is that the Minister of Justice is required to review all legislation before he submits it here, and he has done that. So he's fulfilled his obligations under the Department of Justice Act, and so it's before you to make that decision. But I can't anticipate what courts may or what council may or may not do in terms of challenging legislation.
So assuming that in the future this legislation has been challenged in court, what will be the line of defense?
I mean, if there was a court case, we would be making the same sorts of arguments that we are raising with you folks here to consider whether it's the right tool, which is. We would go through the nature of the tool and the consistency with the criminal code, the consistency with the case law. Those would be the arguments that we would make.
Thank you. So those are my questions.
Thank you.
Sir.
As we try to come to consensus on the amendment proposed by my Bloc colleague, I think it's really important to understand the problem the government says it's trying to solve here with this section, and to stand that solution up against the Bloc amendment, which is similar to amendments that have been proposed both by Conservatives and the NDP, and relates to a concern that was expressed to me by Ms. May. I think it is really important at the outset to recognize that all of the opposition parties have taken issue with the way this bill is drafted around this standard. And I'm going to have some questions for the witnesses in trying to get to the bottom of this in a way that Canadians can understand, because privacy is so important to Canadians. And I know that there are some people at home that are following this issue closely. But before I get to those questions, there's something that I would like to say through the chair, specifically to my colleagues on the other side of the table, because they're the ones that are supporting the bill the way that it's currently drafted with respect to this standard. When I initially spoke to Bill C-22 in the chambers, the issues around the government choosing the standard of reasonable grounds to suspect instead of reasonable grounds to believe attracted a lot of attention. One of our members who practices criminal law practically grabbed me by the lapels as I was coming out of the chamber after my speech to talk about it. And Ms. May also pulled me aside to have a conversation about it. And the reason why it's such a big deal to lawyers, and it's important that people who are watching this at home understand, the reason why it's such a big deal to lawyers and lawmakers is specifically because these questions about reasonable grounds to believe and reasonable grounds to suspect are not just technical legal terms. What they determine is they determine how much evidence and how much work the state needs to do before it can intrude into someone's privacy. And I thought that Ms. Gibner did an excellent job of explaining the sort of basics of privacy law and the kind of tests that the court uses. And I'm not actually going to reiterate the earlier conversation that the committee had with respect to this respect to using the lower standards on production orders in general. I mean, I think the committee got that vote wrong, and I would have supported the block amendment. But the fact that the committee's already made a decision to use that lower standard on the domestic subscriber production orders does not automatically mean that the same standard has to apply in the international context. And so that's the context in which we're discussing the standard here. Now, I thought that, again, Ms. Gibner did a really nice job of describing Spencer, because what that case did is it sort of changed the frame. We no longer sort of look at it and we say this is just basic subscriber information or basic customer information. What Spencer did is Spencer made it clear from a judicial perspective and from a charter perspective that what we're dealing with is what can be highly revealing information that does attract a reasonable expectation of privacy under our Constitution. And it is useful, I think, to think about the ethos of Spencer being here with us in this room, because the reminder and the way in which this debate, the way in which it situates this debate that we're having, is it reminds us that subscriber information is not considered to be neutral under Canadian law. It is often a key that connects a person to their digital life. And once that identity is disclosed, that privacy interest is gone forever. I mean, once you know who it is, you know who it is. And it's one of those it's one of those things that's hard to reverse. And that's why this standard matters. It's why the choice that is made in legislation, the choice of the standard in legislation matters. And so if Parliament chooses the threshold of reasonable grounds to suspect instead of reasonable grounds to believe, what it's doing is it's lowering the bar for the state. And when I say the state, I don't mean it in the sense of the United States for those people who are watching from home. I mean it in the sense of the state, the entity of government that that we, in some ways, takes care of us and in some ways has the power to show up at our house and drag us out at 4 o'clock in the morning, because that is part of the social contract. The social contract that we make is with the state. The charter relates to the things and the role that the state plays in our lives when we have individual autonomy and when we are part of that collective. And so it really matters. And I sat and I listened to my colleague, Madame de Belfoy, talk about how the conversation that we are having here is not a filibuster. It is not something where we are holding up the work that the government wants to do. It is an inherent part of the work that we do in this chamber. And I understand that tempers have gotten high over the last few days and that there is an agenda that the government would like to push through. There are things that they want to do. But we've stood up over and over again in the chamber and said that the government's failure to plan a legislative agenda with enough sitting days and enough time to be able to get the work that they want done through Parliament is not something that should become our problem. We should not be rushing through important conversations about things like as basic as privacy, especially when these are ongoing conversations that are happening in the court, that are happening in our communities. And I just want to echo, I'm not going to reiterate what Madame de Bellefeuille said, but I think it's really important that no one in this room feels like they are being pushed, or I'm not going to use the word bullied, but pushed hard into skipping over understanding what these really important standards do, because we're no longer talking about the standard for a regular production order. What we're talking about when we get to this amendment is we're talking about the same standard as it applies to something called a mutual legal assistance treaty. And that is something that serves a slightly different purpose than the production order. My understanding is that a production order, as we think about it, is a tool that's used by Canadian authorities to obtain information directly from companies and enterprises over which Canada has jurisdiction. When we get into mutual legal assistance treaties, or MLATs, as we call them, because who doesn't love a four-letter acronym? What we're doing is we're asking and I want to make sure I'm correct on this. So please, someone correct me if I'm wrong. That an MLAT actually involves asking another country to use its legal processes to obtain information on Canada's behalf from a company or an enterprise in that country. Have I got that correct? Okay, that's good, because that's where we are in this debate. We are debating the legal standard that should be used when we are asking another country to go get information from one of its corporate persons, I guess. In Canada, it would be a person, but it would be a more of a corporate person or an enterprise. But to go into its database, its information, and get us information, get law enforcement in Canada information that Canadian authorities can then use. And so that puts us into a different realm. It puts us over borders, and it engages questions around international comity, around foreign sovereignty, around cross-border cooperation, and not just with the United States or with countries that are even democratic. It may be the IP addresses could be really from anywhere, and we'll talk about that a little bit, I hope. But it's cross-border cooperation that simply does not arise in a domestic cooperation order. And I think, as Ms. Gibner pointed out, what we have in Canada when it comes to our privacy landscape is something to which there is no comparator. There isn't really a Spencer in any of the countries that we're dealing with. It's a way in which Canadian rights and Canadian privacy rights are unique is a bit of an overused word, but they're certainly not common, and it requires thinking, and that means that we think about these problems in a different way. And so there's been some conversation around the table, but I hope that the way that I've explained this helps make it clear to everybody who's sitting around the table why it is possible that you could have one standard for a domestic production order and a different standard for an international production order. Is that a fair summary of where we're at, Ms. Gibner? Do you have anything you'd like to add to that?
Maybe just in response to your last statement, I would say that it would seem more important to me to Canadians that Canadians protect Canadians' privacy, and so I'm unclear why we would have protections for other countries more than Canadians. That doesn't really make sense to me personally, but.
Well, given that I think that we've got this wrong, and I think we got it wrong on the first question, I'm actually hoping that I'll be able to convince my colleagues through this round of questioning and through our conversation.
But remember how we started earlier before, which is that the Five Eyes partners, the G7 partners, their standards are already less than ours. So we're actually giving those partners our higher standards, if you know what I mean.
Well, do we do that in the realm of forced labor? There are countries who have lower labor standards than ours. We have rules that say that we shouldn't be importing goods made with slavery made under conditions of slavery in other countries. I mean, accepting that other countries' legal standards are lower than ours, and therefore we shouldn't use a higher standard.
So I'm saying the exact opposite, which is that our standards are already higher, and so by working with our international partners, we are imposing on ourselves, or at least this legislation suggests to you, that the right approach is that, yeah, we apply Canadian standards, higher standards on our partners, not that we get lower. For example, we're not having it voluntarily provided to us. We're requiring this lawful authorization at the higher standard that those countries don't impose on themselves.
Well, I wish I'd been here for the conversation about the other clause. I would submit to you that we made the wrong decision on that, and I could make an argument based on Spencer and other legal cases that, in fact, there is a material difference between suspecting and believing. Since I don't have the opportunity to make that argument on that clause, I will make it here instead. And I just want to, you may not, or through the chair, you may not, you may believe that if we got it different, you would have the lower standard on this and the higher standard on the other one. But I just would like you to confirm that the standards don't have to be the same.
This committee can decide whatever this committee wants to do in terms of standards, for sure.
So just moving on to the clause, I just want to have the conversation about this clause. I want to make it clear that I'm having the conversation about this clause independent of the other clause that the committee already made a decision on. So I can understand why the government would want to make it easier and faster for Canadian police to be able to get digital records, especially when the records are held by foreign service providers. That's the goal here. Is that correct?
The goal is to provide officers with timely access to information. At the beginning, particularly at the beginning of investigations.
So what I'd like to understand, and maybe I'll go to Sergeant Gilks or perhaps Superintendent Burchill, whoever wants to answer this question, because the nub originates with law enforcement. So when we talked last week about a different amendment, or it was a Liberal sub-amendment to a block amendment, when we talked about that situation, we were talking about a fairly straightforward fraud situation where you go to get where you go to get information under a production order. How do we get to an MLAT? What changes in that fact scenario that we talked about that gets us into an MLAT?
Thank you for the question, through the chair. I would just foundationally, I may ask my colleague to expand more on an investigational level, but foundationally, we're starting from a criminal complaint. So there's an alleged crime, there's a victim, and we're at the very outset of an investigation with these tools.
So what kind of complaint? Can we maybe, let's just work with a live example. So we had been talking last week about a situation where someone realizes that funds have been withdrawn from their bank account, and there's a how do we get to an MLAT from there?
Well, your investigation is built up very much the same way as it would be if it was a domestic investigation. And actually not much changes at all. It's simply that you've identified that the evidence that you require actually lies outside of your particular jurisdiction. And then you still have to build your grounds as though you were going to be submitting judicial authorization to a Canadian justice or judge. And then you have to go through the process of contacting, in this case, PPSC. So legal services for Canada, which bring you through to Justice Canada and so on and so forth. So it's a considerably longer process.
And how would this bill, how would the tool that's in this bill change that process from your perspective, from a law enforcement perspective?
So change the MLAT process or change the process for obtaining information?
Both. I mean, is it no longer necessary to use an MLAT?
It wouldn't no longer be necessary because in this case, we're not getting the content of the of whatever the service provider would be holding. In this case, we're receiving only a very scoped amount of information, not the actual, so the existence of the records and the nature of the records, but not actually what's contained in the records. I'm not sure if you know.
Is under the old process, did you get what was contained in the records?
So with under MLAT, essentially we were doing that to obtain the contents, including the contents of the records. Because, like I mentioned, it's a rather long process and drawn out. And so if you're going to make all of that effort, whatever you're receiving back should be, hopefully, more complete and as much information as you can receive from that particular service provider.
So why wouldn't you use this tool to get the content as well?
Because it doesn't allow for the content, to my understanding. It's subscriber information and transmission data.
So is it now a two-stage process? So in stage one, you would go, I guess it would you'd still go through an MLAT, no? Because you still have to initiate is there no longer, like, does this so I'm seeing a lot of head shaking, which is great. This is what we need to be able to get to a point where we may end up being able to support these kind of clauses. I mean, it makes a huge difference when, initially we hear a standard that's not the normal standard that we expect to get in criminal law. We hear a different standard, and it is through these kind of questions that we get to understand what the difference is. So you're no longer using an MLAT. This is a different process, and instead of using an MLAT, you would go, instead of using an MLAT, you just go to a judge where? In Canada, in the United States, or in whatever country? Like, you go to the judge in China? How does where, and maybe it's Justice that needs to answer this, but you've identified that, in our old scenario, it's someone has come into the bank, money is missing from their account, you realize that there's there's some IP addresses that have accessed this account repeatedly, you realize that they are not in Canada. Where do you go? Where do you go from there? Who gets asked for what, if it's not through the MLAT?
Monsieur Président, juste avant que Monsieur Wong réponde.
Chair, there seems to be the same word in French and English because the interpreter used the same word. What's that word? Yes, excellent question. I would have asked the same question. Because in English and French, it's the same.
Translators Can Help is a mutual legal assistance treaty, and it is the tool that the Bloc member is amending.
C'est l'interprétation. Vous avez le même mot en anglais. C'est une abréviation.
It's the interpretation. It was the same word in French and English. That's what I'd understood. My apologies.
Oui, Monsieur Lawton.
Oui, mon collègue soulève des points importants.
Lawton. My colleague is bringing up some important points, but she's speaking quite quickly, and I think the interpreter is having a bit of a difficult time, so maybe she could slow down a bit.
Sorry.
Yes, bravo. You would be great at interpreting yourself, Mr. Lawton. Congratulations. The more we hear you speak French, the more impressed we are by your linguistic talents, and so, yes.
Doing your best in terms of not only delivering the flow of information that you would like the witnesses to hear, and obviously the speed at which the interpreter can translate that into French.
Okay, so just getting back to this, in this situation where the IP address is outside of the country, you're no longer going to go through the Mutual Legal Assistance Treaty. You're no longer going to go through the MLAT. What do you do instead if this passes?
Thank you for the question. Premièrement, je vais répondre à
First, I'll respond to Madame de Bellefeuille. I believe that it's MLAT in French.
The scheme of Clause 7, as Sergeant Gilks tried to explain the current environment where there's some inconsistent treatment of this issue across Canada. Some jurisdictions, namely I think BC and Ontario, where the judges are comfortable with issuing production orders against foreign entities. This is a mechanism that works because of U.S. law. So it's not a mutual legal assistance process. Under Title 18 of the U.S. Code, these are amendments that came as part of the Electronic Communications Protection Act. They allow for service providers under that act, as defined by that act, to provide subscriber information and transmission data to foreign authorities when they show their lawful authority to obtain that. So this provision actually takes advantage of the law of other jurisdictions who can provide this information without having to go through the MLAT process. So the way the process is designed for Canada, if Canadian authorities can meet the threshold to obtain that information domestically, the subscriber information and transmission data, they can, before a judge or a JP, also ask for an international production request, which will permit the transmittal of those orders to a foreign entity to hopefully be acted upon. In my earlier intervention, I don't think that you were here, but these are not compellable. They rely on the voluntary provision of this information from those entities.
So then, if I understand it correctly, what this new tool does is it gives you a way to try and get some of the basic subscriber information, the kind that you would get in a production order, without having going to go through the entire MLAT process, without having to go through the mutual treaty process. And if for whatever reason the country that you're dealing with either doesn't allow it or doesn't accept whatever it is that our court produces, then what would happen is you would still be able to go back and go at it through the MLAT process. So there's no...
Exactly.
Right, that's exactly right. So there's no double jeopardy aspect of it. It's simply if you're early in the investigation, as opposed to much further down the line where you're actually looking for more than the content, then you want to be able to use this tool instead of having to wait, having to try and find a bunch of other information. And basically when you run out of other roads, you'll then go into the MLAT process and it's a much bigger production. Is that a fair way to describe it? So I can understand why the desire is there. The challenge is that, and I just want to go back before I ask sort of my next question. I want to go back to understanding why it's so important for Canadians to understand that the trade-offs that we're making in this process. And the exchange that we just had was so helpful, and I hope it's actually been helpful to some of my colleagues who've been interested in this issue and have been chatting about it. We've been chatting about it a lot, in the lobbies and behind the curtains and in the hallways. It's about understanding, like you've helped me understand that it's a much more limited tool. Even though it's sort of couched in the international process, that it's not even a mini MLAT. It's actually really it's kind of apples and oranges. But the reason it's so important for Canadians to understand the trade-offs that are being made is that, I mean, as you know, it's very rare that the debate is really about whether or not law enforcement should be able to investigate a crime. I think everybody wants law enforcement to be able to investigate crimes, and everyone agrees that they should. Where we need to figure out how to draw the line is between where we think about it is the line between public safety and privacy, is the how much evidence should you have in your possession, how much evidence should be required before the state gains access to increasingly revealing digital information. And I think the fact that digital information is so revealing is what sits behind Spencer. And so when the legislators choose this threshold, would you say, do you think that you're expanding through this? What would the standard be? I'm trying to get at whether or not we're actually expanding the investigative power here. So is the standard for this not MLAT process different than the standard that would exist if you were going through a full-blown application under an MLAT?
Thank you for the question. The standard is different, and as I was explaining before, this is designed to take advantage of the laws of a foreign country if they provide this information. As Sergeant Gilks explained, in order to get content, the highly private information, most foreign entities require a full-blown MLAT. I can only speak to how our incoming MLAT process works, and as you explained earlier, it generally requires a request with enough information that we can receive a domestic order in order to obtain it ourselves. And then there's a second hearing. All of this is before a Superior Court judge. And then there's the second hearing is the sending hearing. Once the evidence has been collected, it gets sent back to the foreign entity.
I think, though, the question I'm getting at is that you've made the case that you've made the case on why you believe it should be reasonable grounds to suspect instead of reasonable grounds to believe for the MLAT process, because all you're asking for, I'm putting all in sort of air quotes for that, is the basic subscriber information and not the content of the message, which you would ask for the content under the full-blown MLAT process. When you do the full-blown MLAT process, is the standard currently, before this law comes into place, reasonable grounds to believe, reasonable grounds to suspect, or something totally different?
It's both. So reasonable grounds to believe for the higher privacy interest stuff. We made changes to the Mutual Legal Assistance in Criminal Matters Act back in C-13 when we brought in the new production orders for transmission data and tracking data. So the lower threshold information under reasonable suspicion is also available under the MLAT process for incoming for that type of data.
So that helps to explain things a little bit for me. This has been a really clarifying conversation so far for me, because what you're saying, I think, is that when it comes to this new process that didn't exist before this bill was drafted, the reason that you've picked the reasonable suspicion as opposed to the reasonable belief standard is because the type of information that you are trying to get through this is the kind of information that would have qualified under the reasonable belief as opposed to the reasonable suspicion standard in an MLAT process. Is that what you're trying to explain?
No, it's consistent in both.
That's what I'm saying.
Yeah, it's consistent in both the incoming and the outgoing. And as Ms. Gibner said, we're basically exporting our constitutional standards out to the U.S. when we're asking for information, because we're forcing law enforcement to jump through the hoops for the Canadian standards before they can actually ask this of a foreign entity.
I hear what I want to just make sure I've got 100% right, because it is so important in this context, is that if the request is for basic subscriber information, the test we currently apply under that MLAT process is a reasonable grounds. What the Superior Court judge would want is the reasonable grounds to suspect. And if we were asking for the content, which attracts a higher degree of privacy, and they would want the reasonable grounds to believe. Is that what you're trying to say, or does it all get rolled up into one? Like, how does it work? I'm trying to figure out is whether or not what you're telling me is that the standard that you're using for this is the current standard if that piece was taken out or not.
I would say no, because the current process only exists in the United States right now. So they'd apply the U.S. standard, which, as we explained, law enforcement and district attorneys can get this without any judicial oversight. So that's the standard that would be applied currently. We're creating a standard here, or process in Canada, so that the Section 8 rights of Canadian suspects can be respected, and make sure that police follow all the constitutional safeguards that are required.
But you're describing an incoming request. So if the Americans ask, an outgoing request, so that if we can get it, if the Americans have lower standards, we can take advantage of that. But the question is that when it's an incoming request, for an MLAT, when another country is asking for our subscriber information, when they ask for basic subscriber information now, before this tool exists, do you use the reasonable grounds to suspect test or the reasonable grounds to believe test? And is it different when they ask for content? Like, what are the standards that are currently being used?
For the incoming, you are correct. We would have to use the reasonable grounds to believe, because the only tool available is the general production order.
Right, and so what you're proposing is a different process where we do, in fact, use a lower standard than the one that is currently being used.
Correct, because that is in the subscriber information production order, the last clause that we dealt with.
Okay, and so, well, no, the last clause is not law. The last clause is not law, but it is the wording of the legislation. So I think it's still correct. It's that if it were passed the way it's currently written, that is the standard that would be used. And that, I think, helps lay bare, and I hope that my colleagues, that Ms. May and Ms. de Bellefoy, I hope that this so far has been helpful, because I think we now understand, I hope that we now understand what we are dealing with. It's that under the existing tool, the standards that is currently used, no matter what kind of information it is, for Canadians' private information, is in fact the reasonable grounds to believe test. And what's being created here is a new tool that takes part of that process, extracts part of that process, and applies a different standard, which is more permissive. And so I think, without putting words in my colleague's mouth, that the reason why all three of the opposition parties have put forward amendments to raise that standard in this context, and the reason that I don't believe that Ms. May, I don't believe that the Green Party has an amendment, but certainly I think you do. So, but do you have amendments? Do you have this? And no. So three parties have made an amendment to go to the standard that would normally be used for this information in the current court system. And Ms. May has also expressed concerns to me that, yes, I'm seeing the thumbs up from Ms. May.
I'm not allowed to speak, but I agree with you.
I now want to explain why I think, and I really hope that Canadians watching this at home now understand what was actually a very complicated clause. And I'm glad I see my colleague from the Bloc, Madame de Bellefoy, nodding at this, because I think we're now actually on the same page. It's that there is a new tool that's been created, and it uses a different standard than would be used today for the same information. And I certainly understand why law enforcement wants to lower the standard. I really do. And at the same time, though, I think it's important to remember that the reason why privacy rights are so interesting isn't even the right words, but why they resonate so much with Canadians is because privacy rights are one of those kinds of rights that are often lost quietly and incrementally. When I gave my speech on this in the House, my initial speech on C-22, I talked about a fable, and I'm not going to repeat that fable now because I know that my colleagues across the way are looking for clips. But I would urge people to go look at my speech on C-22 and look at the analogy that was made, because it starts with a situation where it includes a story that talks about how privacy rights are lost incrementally. And privacy rights are often lost quietly. Many people don't actually know when their information has been sought or disclosed. It is one of the features of this digital age that we have to give up so much of our information if we want to be able to use tools that are available to us. And unlike many other government decisions, the people who are affected by changes to privacy rights often never have the opportunity to challenge the decision or even learn that it has occurred. I mean, we learn about so many breaches of our information by email some number of months later. This has been something that the Privacy Commissioner has really grappled with over the years. And what that does is it places a special responsibility on Parliament and on parliamentarians to scrutinize these powers carefully before they're granted. Because privacy is not just an individual concern, it is a democratic one. The countries that do not have privacy rights are often countries where we worry about the state of their democracy. The ability to communicate, to read, to research, to associate with others, and to participate in public debate without undue surveillance is part of what allows a free society to function. And now, every generation, every stage of our being, we face new technologies and new investigative tools. And the challenge for us in this committee is not whether to adapt to those changes, but how to do that while we preserve the freedoms and expectations of privacy that Canadians rightly value. And that's why debates over clauses like this matter. They're not merely technical amendments to a statute. It's not the choice between believe and suspect may seem like it is mundane to our colleagues across the table. But when all four opposition parties and so many experts have come to committee to highlight the difference between those words, I think it is really important and it deserves careful scrutiny and understanding. And so with that, I really want to thank the witnesses again for helping us understand what the difference, what it is that matters here. And while I would submit to you that not only has the conversation that we've had over the last few minutes been illuminating with respect to this clause, but I think it's also explained, I hope, and validated why it is that the opposition members of this committee from all parties voted against this standard in respect of the production orders. Because I agree with Ms. Gibner. The standard that we apply, the standard that we give citizens from other countries should not be higher than the standard that we give to our own citizens. But what this conversation has revealed is that we do have a change. It is a new tool, but it is a tool that allows for information that would normally have to go through another process, that would normally attract a higher standard of scrutiny. It allows that information to be received using a lower standard. And what we haven't talked about, and what I suspect one of my colleagues is going to cover through some of the case law that he's brought with him, is why it matters And this is where I am at some point. I'm for later. What is it? Is it for later? All right. Well, but it's going to come up in this. Is that we've talked about? I think we now understand the difference and what we're doing here. But the issue is that the standard of reasonable grounds to suspect as opposed to believe, that suspicion as opposed to the higher standard, usually applies in situations where there is exigency. It usually applies in situations where there are special concerns. And I would note that this is not a tool that can only be used under exigent circumstances. It's a tool that has been created to be used by law enforcement wherever it sees fit. And that is why the standard and the difference in the standard matters. And so I'm going to stop there, Mr. Chair, because I think I've done a piece of the work that we need to do. I think I've done a piece of the work that we need to do in this committee. Which is to get us all on the same page as to what it is that we're talking about here, what the difference is between the existing standard and the new tool that's being created, why it matters in the context of privacy law, and I hope that this conversation will allow us to really be able to make a good decision about which standard we should choose, the standard that already exists or the lower standard that the government would like to use in this bill. And it's up to them to justify why using a lower standard is necessary. And while the witnesses have been wonderful in explaining how they would use this and what it is, I haven't actually heard the case for why it's necessary. So I'll stop there, Mr. Chair. Thank you very much.
Thank you, Madame Coronis. You have raised the excitement bar quite high, and now turning to MP Caputo, who will certainly meet that standard.
Oh, boy.
Thank you.
I want to, the MPs are smiling, but I do want to take a moment to thank the officials. I know it can be difficult, and we have moments of levity among members, probably because it is now June, and this is kind of silly season when it can be very difficult. A lot of people are working 15-hour days, yourselves included. So we do thank you for putting on a brave face. I know you're not allowed to show the levity that sometimes we are, so we really do appreciate you being here. I'm not going to take a super long time here, famous last words, because they say no, because I am going to ask for a washroom break when I'm done. Full disclosure. But this is but this is something that was actually brought up by Professors Geist and Diab. I'm not sure in your preparation. I know that you all have robust preparation. Did anybody, Professors Geist and Diab appeared on the same panel. Can I ask, did anybody review their testimony on the panel? Yep. So they both talked about the grounds to suspect versus the grounds to believe. Is this resonant? Is this triggering for anybody? Now, one of the things that both of them said, as I recall, but I'm pretty sure it was Professor Diab, definitely said, but I thought both said, was he said that a lower threshold of reasonable grounds to suspect generally would invite scrutiny under Section 8. There's always scrutiny under Section 8. What I say by scrutiny under Section 8, perhaps a declaration of unconstitutionality. So we can sit here all day, all night, but if a law is declared unconstitutional at the end of the day as having breached Section 8 and not having been saved by Section 1, all this time we spend is kind of in vain, really. One piece of litigation working its way up through the Supreme Court of Canada, up to the Supreme Court of Canada, which invariably these types of cases do, then there's an issue there. So I want to ask about this. I would like to ask about the official's point of view. My recollection is that the professor said that a lower threshold of reasonable grounds to suspect would breach Section 8 of the Charter. Now, the government doesn't believe so. I've looked at the charter statement, and I don't think that the charter statement really tells you a lot. It says, well, this right is engaged, but we're kind of doing this. It doesn't say a reasonable ground to suspect will not invite the court to strike this down because this case and this case established this. Based on that, we come to this conclusion. That's what I'm looking for from a legal statement. I think we would all want that from a legal statement. So I would like for somebody to address this question. Professor said the reasonable grounds to suspect threshold offends a Section 8. What do you all say to that?
I'll start that question. I think everybody, you're asking everybody, so I'll start the conversation and let others chime in. But obviously, you know that we're here to assist the committee and answer questions. We are dedicated public servants that work on these issues day in and day out, and some of us have been accused of being advocates for the bill because I think we are passionate about serving you, and so we definitely do not think that it offends Section 8. But it's going to be up to this committee to make that decision about the standard. We're here to make sure that you have the information you need. We've tried really hard to set out the thinking, and that's what we're here to do, is to make sure that you have the answers to your questions. And so, as without repeating myself, I always want to start with first principles, which is what is the purpose of Section 8? It is the balance of the state interest of law enforcement and privacy interests. Spencer was about whether we were even in the realm of Section 8, whether there was a privacy interest at all. The court was confirmed that we are, that the world of policing had changed. And so for this type of information, they needed lawful authority. And so when we're drafting a bill for your consideration, we are looking at the state of the law. There's all sorts of reasonable grounds to suspect. Somebody pointed out to me earlier today, one of the provisions you probably dealt with more in your career than I did, which is, the reasonable grounds to suspect for a roadside breathalyzer. That's reasonable grounds to suspect, right? So there's all sorts of provisions in the code. There's all sorts of law enforcement tools, like the use of sniffer dogs, that is the reasonable grounds to suspect. And the courts are consistent that the reasonable grounds to suspect is a criminal standard that has been around forever. It is lawful authority, and it is in those situations where the search is in comparison to your general production order or your search warrant to your home, which requires reasonable probable grounds, the reasonable grounds to suspect is for more narrow, targeted searches. And so, again, you'll remember that the reasonable grounds to suspect is also built with the tool itself, meaning that in the reasonable probable grounds, it is of that there'll be an evidence of a commission of offense. So you are looking at building a case with an evidentiary perspective. But in the reasonable grounds to suspect, it is at the beginning of an investigation where in this case, for these tools, it's about obtaining information, not evidence at all. So again, tailored, narrow, small, judicially authorized, safeguards of judicial review. The reasonable grounds to suspect standard was chosen, and we do not think that it violates the Charter, or we wouldn't have put it forward.
Right. Okay. So I'm just going to think about this because you did use the example, and I appreciate you bringing the breathalyzer example. The law did change in British Columbia a number of years ago that basically meant we didn't really prosecute a lot of impaired driving charges. But I do recall there were reasonable grounds to suspect that a person had alcohol in their body. Now, as I recall, there was, I can't remember if it was an arbitrary detention issue or not, but it did have to go to a Section 1 analysis. I think it was, I can't recall if it was a Section 8, the search in terms of providing a breath sample, or the Section 9, the roadside detention. I guess, you know, and I always really appreciate, Ms. Gibner, how you do engage in the law and discussing this, and I think you articulated that quite well. And I don't think anybody at the table there would say something along the lines of, look, we really want to put law forward that's unconstitutional. Now, we still have to scrutinize that. Of course, you're not going to put forward unconstitutional law. I don't think you would have your jobs. Now, with that being said, I think C2 had blatantly unconstitutional provisions in it. I'm not going to bust out parts 15 and 16 in it. And, you know, with the greatest of respect to officials, I think that the legislative drafters are told what to put in. And I think that there was probably language in there that 9 out of 10 lawyers, constitutional lawyers, say, yeah, this probably offends the charter in C2. So the mere fact that something has been drafted, I don't think is persuasive enough. I take it on your face. Look, we're not going to put something in that we know is unconstitutional. But what we worry about is the gray area. I guess what I'm asking for you, and tell me if this is an unfair question, because I asked Professors Diab and Geist about this, as I recall, but they articulated their rationale for why this offended Section 8. I don't recall exactly how they drew, how they connected the dots, but I guess what I'm looking for is, do you simply disagree? Where do you depart from their analysis? Do you recall their analysis? I mean, this was a couple of months ago now, so help me out there, please. And if you can't recall, I'm not going to be offended or anything.
I'm going to let my colleague answer that. I don't recall what their arguments were, so I can't respond, but I think my colleague can.
Thank you, and I'll try. And I don't want to comment directly on the testimony or their evidence that they produced, but I would just say that you know, they're lawyers, we're lawyers, we have opinions. Our reading of the Spencer decision, and as Ms. Gibner has said, leaves space to develop lawful authority by other means. And we've talked previously about administrative schemes that could have stood up as lawful authority to access subscriber information. This government decided to go for a more robust judicial oversight. So the court didn't stipulate that it must be judicial oversight, but that was what the government decided to put in this bill. The reasonable suspicion standard was chosen because of the type of information it is, and as we've explained before, the reasonable grounds to believe standard is usually reserved for gross invasions of privacy, like police coming into your house or the contents of your banking records or everything else. So when you're constructing these tools, you have to put them on a privacy spectrum. This information, in the vast majority of circumstances, will only identify the person involved in criminal activity or exculpate, as Sergeant Gilk said, when we find out that the person is just the pizza delivery boy. So this is the reason why this was chosen. You know, in terms of working on the policy for these things, challenges to their constitutionality are commonplace. It happens all the time. You know, as Ms. Gibner said, you know, it isn't in our business to introduce or put together policy that would be unconstitutional on its face. There's a requirement actually in the Department of Justice Act for the Minister of Justice to inform Parliament if that's what he's going to do. So
right. Okay, so you raised an interesting point. You've both been very articulate in how you've addressed this. One of my questions, and potentially a concern here, is you talk about spectrums of privacy. Obviously, the body generally attaches the privacy in one's body probably attracts the greatest privacy interest. But you know, these things here, there's a lot of privacy in there because they have all of your details. They're essentially walking biographies of who we are. You know, in some cases of who we are that people might not want other people to know about, things like that. They contain substantial information, so they do attract a high degree of privacy. Even your modules in your car. There's a BC Court of Appeal case about your module that records information for the last 3 seconds before an accident. These are the types of things that still have an expectation of privacy. On the spectrum of expectation of privacy that you've just outlined, Mr. Wong, is there agreement, either academic or jurisprudential, on where these issues here that are covered in this clause in this amendment stand?
Thank you again for the question. One of the aspects of this clause is the request for transmission data. This production order has existed at the reasonable suspicion standard since 2014-15. Its complementary transmission data recorder warrant has existed since 1993, all at the reasonable suspicion standard. So it certainly has existed. As we know, there's no specific tool for subscriber information, but the type of information available in the subscriber information production order is largely already available under the financial information production order.
Okay. I'm just wondering, Mr. Chair, could we have a washroom break, please? Dilatory? Yes. Yeah.
I don't think we want to have that, given that we have had 3 series of 50-minute breaks until now. So I'm being tough, but I think
you are much more robust than I in your fortitude.
That is not true.
Did we have a motion to adjourn?
But you may want to continue. Otherwise, I'll turn to another MP, and you can come back after.
Who else is on the list here?
I have MP Housefather.
Oh, well, this should be good. I'll be fast. Okay, thank you.
Okay.
Go ahead, Anthony.
MP Housefather.
Thank you very much. I particularly enjoyed Ms. Cronus's 56 minutes, although she's somehow has not stayed for the vote on this, which is shocking. Can I just I just want to understand. Number one, would you say that consistency is important when you're using standards related to whether you're going to use reasonable grounds to suspect or reasonable grounds to believe if it's for exactly the same thing, such as seeking a production order?
I think that you've heard both from Mr. Wong and myself that that's a key that we're looking at when we're proposing legislation for your consideration is consistency.
So for example, if you had the question of deciding whether or not a breathalyzer test was something to be sought, and you, for example, had one separate provision in the code that said that if you smell alcohol in somebody's breath or they have bloodshot eyes or other observational signals of how the signs on the driver look, and you were to say that you would use reasonable grounds to suspect in order to enable the officer to order a breathalyzer test at that point, and then you had a separate infraction or a separate provision in the code that talked about observational driving and where you saw the car swerving from side to side, it would be important to use the same reasonable grounds to suspect in both cases and not have one be reasonable grounds to suspect and other one reasonable grounds to believe in order to order the breathalyzer test. That may be a bit convoluted, but essentially you're coming to the same point. You have reason to suspect that the driver might be impaired, and you have different ways of assessing that. One would be, for example, the physical signs such as they're slurring, their eyes are glassy, etc. And one would be how you observe them to drive. it would make no sense in that case for you to have determined that one would be reasonable ground to suspect and one would be reasonable ground to believe. Would you agree with me in that case? You would never recommend to the Minister of Justice to put two different standards in the bill for essentially the same type of activity that causes an officer to want to order a breathalyzer test.
Consistency in the criminal code is key. So I would agree with your proposition.
And in this case, we have already determined whether the committee agreed with it by majority or didn't agree with it by majority, what standard we were going with to ask for a production order to be at least within the domestic scope. Correct? And and the committee voted by majority to go with reasonable grounds to suspect. You were there when that happened.
Yes, and I echoed something similar earlier, which is that it would be pretty nonsensical to me that we would have a production order for Canadians and then to do something different.
And then use a higher standard to have a production order in a foreign country. It makes no logical sense to me either. Regardless of whether people agreed or didn't agree with the original decision, you can't have inconsistencies across the law.
Sorry, MP Assad. Again, you're extremely, well, not extremely, you're somewhat dense and fast, and given that the interpreters have had a long night until now, you may want to just go slightly slower. Yes.
Okay, je vais ralentir.
Also done.
So basically, given that we've already made a decision on the domestic reason to suspect, it would seem strange to use a higher standard for an order that we're seeking in a foreign country. And it would create a very, I think, unusual law where we're imposing a higher standard in a foreign country than in our own country. I think you've echoed that already, right?
I think I've said the same thing.
So essentially, I guess my point, Mr. Chair, to colleagues is whether they agreed with the original decision or not, the decision is there. The law is written that way already. We don't go back in committee. We only go forward. And now we're spending about 2 hours so far on this one amendment to somehow argue that we should have an anomalous higher standard for a production request in a foreign country than we should have domestically. And to me, Mr. Chair, that makes no sense whatsoever. And this has been 2 hours of an absolute waste of time on this debate because essentially the decision was made and there's ample hours of discussion about what standard to use a couple of days ago when we decided what standard would be used domestically. And no good lawyer would advise that you create different standards for the same thing in the same law. Sorry?
We're talking about you guys. You voted wrong. That's right. Carry on.
Yeah, I mean, thank you for allowing me to carry on and not fall into this very strange type of situation where we're pretending that it's okay to just disregard what the committee decided a few days ago with respect to the standard to seek a production order.
Point of order, Mr. Chair.
So, Mr. Chair, anyways, I don't need to go. Sorry?
Point of order.
Yes, please.
No one is disregarding what was said. I think we were very clear in that we think the committee got it wrong.
That not only is that not a point of order, you also specifically said in your own remarks that you were disregarding the previous decision and assuming that this was in isolation and going forward with your arguments. I listened to you for 56 minutes. So in any case, Mr. Chair,
wasn't 56 minutes.
You had 56 minutes. Let Anthony speak.
Yeah, father is going to say something important.
Again, I would have wrapped this up in 3 if I hadn't been interrupted. But in any case, Mr. Chair, I do believe that this is just at this point a pointless debate. We have an amendment again. There's dozens of amendments, and we've gotten through one today. And I think that makes the point of the complete lack of seriousness with which some people are taking this discussion. Thank you.
Thank you, MP Housefather. I have MP Mantle.
Thank you, Mr. Chair. Just a short intervention in response. As Mr. Housefather will know, there are several different powers in the Act, which the government is choosing to change the standard in each of them. Several of them are different, actually. So the confirmation of service, for example, is one. The production order is another. And at least the third one that comes to mind is the requirement for tracking information, which will come up in an amendment shortly. So those are actually all three different powers under this Act, which each can demand its own discussion of what standards should be applicable in those. Thank you.
Thank you, MP Mantle. Et par conséquent, est-ce que l'amendement B...
Is BQ7 adopted?
Recorded division, please.
Si vous pouvez, Madame la Greffe, procéder un appel nominal.
Madam Clerk, please proceed to a recorded division.
No.
Mr. Housefather.
Against.
Mr. Pawlowski.
No.
Mr. Danko.
No.
Madame Dandurand.
No.
Et Madame Soli.
No.
Mr. Caputo.
Yes.
Mr. Lawton.
Oui.
Ms. Kirkland.
Yes.
Monsieur O.
Yes.
Et Madame de Bellefeuille.
Pour.
Yes pour 5, 5. Nays contre.
Nays against 6. Thank you, Madam Clerk. BQ7 is not carried. We're skipping over CPC4. Is Article 7 carried? Yes. Clause 7. Clause 8. Does Clause 8 carry?
Please.
Lots of papers.
Go ahead. Sorry, Mr. Chair. Yes, I just want to make sure I'm following you. Okay. We have no amendments to clause 8. Is that correct? Okay. Yes, on division.
L'article 8 est donc adopté.
Carried on division.
L'amendement NDP 6 est...
NDP 6 was put forward. Is NDP 6 carried?
Oui.
Thank you. Thank you very much. So my understanding is that the current framework deliberately leaves timelines to judicial discretion. Correct me if I'm wrong, so that production orders can be tailored to the facts of a particular investigation. So can you walk me through why that flexibility was built into the regime, and what could there be any operational challenges if Parliament were to prescribe a more rigid approach as is recommended in this amendment?
Thank you for the question. The original production order framework left it to the judge to have the discretion to decide the time and place and format for the production of the data. And this is primarily because police might ask for different types of information that may be easier to compile in some instances and harder to compile in other instances. And depending on the scope and range of the production requested by the police, it may entail a lengthy process. So leaving it up to the judge is appropriate for the circumstances. What happened since the introduction of the production orders, there's a provision in here that allows for the entity to object to a production order, and they have a certain amount of time in which to object. And that time is any time before the production order or the production order is due, and at the very least, or at the very most, by 30 days. And they have to inform the peace officer. And the reason why 30 days was chosen was because we didn't want the entity holding the information to wait till the clock ran out. So let's say it was a lengthy production and the judge granted 90 days for the production. We didn't want them to wait 90 days to tell the police that they weren't going to produce. We wanted to be able to inform the police at an earlier date so that the police could decide on whether or not they would wait for the eventual production or pivot and try a new investigative technique. So the motion as presented here would standardize a 30-day return, which is basically what police already have and which has been highly problematic, especially since Spencer. And this provision applies to all production orders. So even where return dates are shorter currently for the other types of production orders, the other lower threshold specific information, this would standardize a time of a minimum of 30 days. And like I said, the way that it's written here, 30 days, that doesn't give the judge discretion to order a longer time if the production is more lengthy.
Merci. J'avais précisé aussi que si, comme cet amendement est...
Thank you. And as this amendment was tabled, the one following cannot be put forward because it is identical to NDP 6. Mr. Mantle.
Thank you, Mr. Chair. I want to ask the police to tell me a little bit about when you, because we had a conversation on Tuesday, I think it was Tuesday, and we were going through some of the problems in when you write a production order, trying to get that perfect, and this back and forth that happens. How long does it usually take to get a response for one of these production orders? Or is there maybe categories depending, you know? It was about something different. I know you weren't here, but it was a similar topic, but...
Mr. Chair, there's a new member. Can you call them back because my patience is running low?
Je pense que le ton a été bien.
I think the tone was well understood, Mr. Mantle.
To Mr. Gilks, how long does it take to get a response, typically?
Thank you for your question, Mr. Chair. I hate to answer questions like this, but it does depend. So it depends on the service provider. There are some which are somewhat slower than others in terms of response time. It also depends on the type of request that's going through. For example, if there's a request for subscriber information, it would typically go faster than, let's say, a request for something like a tower dump where you have to produce many lines of information that typically have to be manually extracted. And so this is something that also generally can be part of the back and forth with the police officer and the service provider that's actually providing the information. But generally, it can take a considerable amount of time with some providers. And please keep in mind that these are cascading timelines. So your first return of information, if it's within 30 days, and then you write a new production order based on the information that you receive. If there's another 30 days, you're at 60 days within your investigation, and you have a lot of downtime waiting for what actually might come next before you move on.
Yeah, fair enough. I would say it depends is probably my favorite phrase ever as a lawyer. That's the best answer to give a client. It depends. So that doesn't bother me in the slightest. But we just heard from Mr. Wong. I mean, some of them were, up to 90 days. So, I mean, and I assume that could be a situation of a cascading return as well. I mean, if you're not getting the first one for 90 days, then you're not getting the next one for, et cetera, et cetera. So that seems like that problem exists now, does it not?
Correct. That is a problem that we do experience now.
So would it not be helpful then to have some standard baseline? I mean, at some point, picking a number, becomes somewhat of an arbitrary exercise, and you do it based on the best information you have, your experience in dealing with this. But would it not be helpful to say, okay, well, let's set a baseline to start? I mean, 30 days is certainly faster than 90 days.
This is an accurate statement. I'm thinking if I had to provide an opinion on this, well, in that case, based on the restrictive information that's to be provided, that would be, for example, something like subscriber information, which generally should be quicker to secure and produce than a reduced turnaround time would be beneficial to police.
Yeah, okay. That's helpful. Thank you. One of the other problems that it appears to me, at least in this situation, is that I've been gathering throughout these exchanges that there seems to be a what I'll call a lack of respect for when you do get one of these orders from the companies that they're issued to. I mean, my understanding, and Ms. Gibner can correct me, I mean, these are in the case of a production order, it's a judicial authorization. If a company doesn't respond to that, per the terms of their order, that's contempt of court. Is that right, Ms. Gibner?
Thanks for the question. I'll answer. The production orders have their own penalty scheme. Okay. So when we originally did the production orders back in 2004, the contempt of court was seen as perhaps too draconian or too severe for production order. And since many of these production orders would be served on corporations, it also poses some prosecution issues too. So there is a fine scheme that comes with not obeying a production order. But I think our law enforcement colleagues have talked about this before, and I certainly have. Production orders are to be served on cooperative third parties, and that relationship's very important. So, and I think Sergeant Gilks was getting to the point of the back and forth between him and a service provider. So sometimes there might be a little slack in terms of the production because the service provider's having problems. It wouldn't benefit Sergeant Gilks to report this service provider and ruin the relationship. So the whole scheme was designed to be used with cooperative third parties. There are other tools in the criminal code when they're not cooperative.
Thank you. Yeah, I take your point about cooperation. I guess my point would be sometimes priorities are differently organized depending on the recipient of it, and in my experience, sometimes responding to your request may not be at the top of their priority list, especially if a penalty scheme is not a sufficient motivating factor. What is the penalty, Mr. Wong, for failing to comply with the production order?
Thank you. They're found at 487.0198. And there's the possibility of fines or an offense on summary conviction as well. No more than 2 years, less a day.
And is in your experience, maybe yours, Mr. Gilks, or yours, Mr. Wong, is that operating as an effective motivating provision? It seems like from the discussion previously it wasn't.
Thank you again. As I mentioned, there are other tools in the criminal code that police can use, including a warrant power, and that's when police will go in themselves and get the information. To my knowledge, that has generally worked to get compliance with production orders because it's less disruptive to the service provider to get the information. So I think the production orders have largely been a success. Perhaps my colleagues from the RCMP have a different opinion, but I think they've become the most used tools in the criminal code since they were introduced.
I don't know if you have anything you want to add. That's fine. Yeah, it seems like ultimately, you know, from what I've heard, you do end up getting information, but it sometimes is either this ping pong or iterative process, or you don't get what you needed in the first one, so you got to go back and do another one, and all, of course, that goes into the problem of time, which I'm sympathetic to in these investigations. So that's why this amendment was interesting, because it sort of provides at least some baseline. Both for the police to know, okay, well, we've got a deadline. Maybe it's, you know, for a simple one, maybe it's, you know, in your opinion, maybe too long. They should be able to do it more quickly. But for longer ones, you know, on the company side, maybe that's a motivating factor to say, okay, we've got a 30-day deadline. At least that gives you something to shoot for, because it seems like right now, when we're leaving it up to the judge or the justice, like we're still having the same problem where deadlines come and go, and information is not provided, or you have to go back and ask again for something else. So it seems to me that having at least some starting point would be beneficial. And I think you said as much, Mr. Sergeant Gilks, to have something would help. Now, at the same time, you know, I'm sympathetic to, you know, in some cases maybe you need something quicker. And in going through the code, especially on some of the, coincidentally, some of these standard issues for certain offenses or defenses, there's reference often in the code to exigent circumstances. And I was doing some review on that, but Ms. Gibner, can you tell me when the code speaks about, or Mr. Wong, when the code speaks about, you know, for example, normally to enter, you know, a dwelling place, you need to have, you know, higher threshold. But if, and I'm just paraphrasing here, you know, if you think that somebody is committing a crime and going to injure someone, you know, grievously or kill them, then there may be exigent circumstances, and you can enter that, you know, enter that dwelling place on a lower standard. Can you give me a little bit more color on that idea of exigent circumstances? Because I'm going to use that in a sec, I think.
Thank you for the question. There is a provision in Bill C-22 and my eyes are not really working right now, but I think it's Clause 14. So I won't be able to read you the provision because I forgot my glasses today. But that is an amendment to the exigent circumstances codification. So that allows police to act without a warrant, both under the reasonable grounds to believe or reasonable grounds to suspect thresholds, when exigent circumstances exist and it would be impracticable to go to a court to receive an order. Again, this is the codification of the common law. Whether we made the amendments here or not, they would still exist. But generally, and I think I've mentioned this before, when police act under exigent circumstances, it comes with a great deal of judicial scrutiny, and they have to demonstrate that they acted reasonably in those circumstances. And the ability to act in exigent circumstances only lasts as long as the exigent circumstances exist. So they can't exist at one moment, but a couple hours later, if they don't exist, they can't continue to act. So it's very onerous in terms of the proof that they have to show that they acted reasonably.
Thanks. Is that a, I mean, you said it emerged from the common law. Is that I guess then a fairly well understood concept in the code?
I think it's fairly well understood. The Supreme Court in Spencer talked about the ability to act in exigent circumstances, and the recent Supreme Court decision in Campbell also talked about acting in exigent circumstances.
So would there be a way to either use that concept or another to say, let's start with a baseline of 30 days, or I'm open to another suggestion on what that might be, but if necessary, or if we have exigent circumstances, you know what? It's not going to be 30 days. The judge could vary it and say you need it in 7 days. Could we do something like that?
You could do something like that, but I don't think it would be consistent with the scheme here. There are other amendments other than the one that we're talking about right now at 47.0193. I think it's clause 10. There are no motions for that, but that spells out a new timing regime for the ability to object to a production order. And and the connection's not really clear about the return date and the objection date, but what's happened because this provision applies to all production orders, the return date or the objection date was actually interpreted to be the return date. So almost by default, a lot of production orders are issued with the 30-day return date right now. You have to remember, and Ms. Gibner talked about this, prior to Spencer, there used to be a database that police were able to poll in real time to get customer name and address information in relation to a phone number. So it was in real time. Most of our Five Eyes partner countries can get this information within hours or within days. So to have a 30-day timeline, I think, would perpetuate the issue that police are having currently, which is a delay in getting very basic information at the beginning of an investigation. And as Sergeant Gilk said, it has a cascading effect because this is just basically the start of an investigation. And if there's a 30-day delay and the next there's a 30-day delay, before you know it, you're a few months old. And in terms of investigations of cybercrime and crimes that happen online, it may not be the subscriber information that's at risk of being lost because service providers need that to bill you, but it's all the other information that will actually lead you or connect the crime that might be at risk because there's no standard for how that information is kept.
Yeah, fair enough. And I would just reiterate, like, I'm unsympathetic to that argument, and it's been disappointing in this process to hear sort of, lack of respect or priority issues or whatever the case may be, lack of resources for certain smaller companies who are responding to this. When I dealt with this, I always would say to clients, I know it's not your day job to be filling out information for me as your counsel to be giving it to whatever government entity we're working on. So sometimes it's just an issue of resources, and there's both sides of that coin, what you need and what they can provide in a reasonable time. So I'm going to propose a sub-amendment to this that I'm going to I'll just provide orally, and then I can email to the clerk for the translation. That I'm hope we'll try and set this stage for 30 days, but then also provide an opportunity. So, Mr. Chair, the current wording of the motion in CPC 6, or it's the same in NDP 6, says, named in the order within 30 days after the service of the order and at the place and in the form specified in the order, and here's the amendment, comma, or within such shorter period as is specified in the order where the justice or judge is satisfied that the circumstances make a shorter period necessary. And then the amendment would continue.
To see whether that amendment is admissible, or this some amendment is admissible in relationship to the amendment itself, and obviously we'll have to see this some amendment in writing. So otherwise, there is no way we can make any useful progress. So
I can email it to.
Well, you'll have to do that. Otherwise, we will not be able to proceed. at any speed. So for that to happen, it will also need to be translated and checked by the clerk. And so lots of steps to proceed. So I'll have to suspend for the time it takes to consider that a sub-amendment.
resume. Thank you for coming back. Before we suspended, we received a sub-amendment for NDP 6. This was put forward by MP Mantle. The English and French version of this sub-amendment were sent to you by email. You should have received it just now. At 11:18, Mr. Mantle, would you like to continue?
Point of order.
Point of order?
Yes.
MP Lawton?
Yes, I have not received the sub-amendment.
You may not
But
have
I am
been-
subbed for Mr. Lloyd, so
Yes,
I hope I can receive
you'll
it,
be
please.
sent that. Anyone else who did not receive the sub-amendment? Okay, anyone else not having received the sub-amendment? No, everyone else has it, so you'll receive that in a couple of seconds. MP Lawton, MP Mantle?
Thank you, Mr. Chair. So the purpose of this amendment, or sub-amendment, I should say, sorry, to NDP 6, and I think Ms. Kwan has joined us, so I'm eager to hear her thoughts as well, because it's ultimately her amendment, although similar to CPC 6. But what I've heard in the last meeting or so of testimony is that there is a problem with the police being able to get the information through the production order, at least as it's conceived currently, in a a time that they would feel is reasonable. Now, taking them on that assumption, or taking their view, I'm sympathetic to that, because there seems to be a bit of an iterative process that takes place. Partly it can be seems to be just the nature of the investigation, but also partly can be what kind of frustrates me a little bit, which seems to be a reluctance on the part of the recipient of a production order to, maybe I'll say, prioritize that. And I've seen that in my own legal career. Companies often have limited resources, just like government or anyone else, and so responding to regulators, or in this case law enforcement, they may not perceive to be at the top of their priority list. But in my view, it should be taken seriously when a production order is issued to an entity, whether it's a business or other type of person. And so what I think I'm trying to achieve here is take the spirit of the amendment from Ms. Kwan, which is to sort of set a baseline of 30 days to respond, and that provides at least some target, both for the police to understand when they might receive information, but also for the recipient of the order to target for the production of that information in response to the order. Now, I accept that 30 days, that seems to be, from what I've heard from Mr. Wong, a bit of a codification of what is already practice. So the 30 days itself, in my view, is not arbitrary. It's a codification of existing practice. So that's a good starting point. But sympathetic to the idea that in some circumstances, actually, maybe that's too long, especially in the case of if the production order was more narrow based on the investigation itself. So what I wanted to try and do with the sub-amendment is say, keep the spirit of the 30 days, but then also keep what Mr. Wong said was important, was the discretion of the judge to tailor that requirement to the situation. So 30 days would be the upper limit of the starting point. But then if the circumstances were to demand it, the judge or the justice could decide on a lower or a shorter period, I should say. So that seems to satisfy, at least in my view, both both issues. So that was my intent of bringing this forward. So I'll pause there and hear from perhaps Ms. Kwan, it was her amendment, and my other colleagues, and then maybe I'll have some other thoughts after hearing them. Thank you.
I have MP Lawton and then MP Akan. MP Lawton.
Thank you, Mr. Chair, and I can't thank my colleague, Mr. Mantle, enough for this. This is a phenomenal sub-amendment, and I think my colleagues agree. I see them smiling and lighting up at this late hour. And I think that his sub-amendment actually speaks to the collaborative spirit that we've been striving for with this bill. We have a conservative sub-amendment to an NDP amendment to try to improve a flawed Liberal bill. This is, I think, working across party lines to try to, again, strike this balance that we've been talking about now. And I think it's very important. And I think it also stresses that, our efforts from the get-go, and not just in C-22, Mr. Chair, but also in other laws and bills and acts. I have the great pleasure of serving on the Justice Committee. And, one of the things that has been front and center in a lot of the work that our party did in the last campaign and that I've been tackling on the Justice Committee is trying to give law enforcement the tools they need to use the sort of the colloquialism we've heard in this committee to go after the bad guys, and to have the tools and resources they need to do so, to ensure that they have laws that are going to keep these people behind bars and not, just as has been the norm after 10 years of Liberal reforms to criminal law, letting them back out on the streets. And we agree wholeheartedly that there needs to be a modernization of our laws, which is why Part 1 has been so uncontentious, and why we were hoping that we would get support from the Liberals to work through these amendments and give police the tools that have been most often cited. And the number one issue, when Bill C-22 was first tabled, and I canvassed the law enforcement in my riding and other stakeholders and people in the community, what they talked about was wanting to have a clearer path, a more streamlined process, and more importantly, a quicker response on getting production orders. And we know that confirmation of subscribers, of subscription information was a key part of that, because oftentimes law enforcement had to have this two-part process. They'd have to spend time tracking down where an individual had an account before they got before they were able to know what to fill out on the request for a production order. And, this was, again, a very real issue, and one that I think, again, all of us would want to find an answer to on this. And I think that why that's relevant right now in Ms. Kwan's amendment and now Mr. Mantle's sub-amendment is we want to make sure that we are not creating a floor with the 30-day requirement. And I think what Ms. Kwan has tried to do is actually very important here. I've heard oftentimes quoted this legal precept. I think Bruce Party at Queen's University often cites this, that a right without a remedy is not a right at all. If we have this expectation that telcos and service providers have to turn over information, but we don't prescribe a window, we really haven't mandated what we're trying to mandate. But we don't want to have happen, and I'll note that the Liberals are, through C-22, also trying to force companies to conform their systems and their processes to the law. We don't want companies to create a process that basically turns back this information in 29 days, and where information could be and needed to be returned more quickly, it's not able to be. So I think that the 30-day limit is an important one, but I also want to make sure we're not creating a floor there, that we're actually acknowledging that there are exigent circumstances. There are situations in which members of law enforcement will need to move on things very quickly, but, and this is the crucial point, we still have to have judicial authorization for that. We still need to have a judge acknowledging the urgency of this. And look, we know there are times when our brave women and men in uniform, are there in minutes when minutes count. And this is something that we need to be very mindful of. I come from southwestern Ontario. About, I think it was 11 or 12 years ago, other colleagues may remember, there was a thwarted terrorist attack in Strathroy, Ontario. And I was working in radio at the time. And, Strathroy is not the town you think of when you think of there being a terrorist attack. But there was someone who had loaded up a homemade bomb in a backpack I had called a taxi. There have been conflicting reports about where he was headed and how. But the reports that we learned after the fact were that this was actually like literally a Hollywood script in terms of just the timing of the law enforcement intervening. And they actually had to get information from the FBI because of gaps in the Canadian intelligence and investigative system. So I'm not denying that these things are real. And while it is important that we work with other countries, that we get that intelligence, we also don't want to have to rely on other countries to do the intelligence and investigative work. So we do have these situations where seconds and minutes count, and we need to be responsive to those. We know there are situations in which, horrifying, but children are being abused, and we need to be able to move quickly on this. So having a framework built in directly to the law in this particular section, and this is, I think, so key, in this particular section that acknowledges the importance of exigency and the legitimacy of that and the necessity of being able to respond quickly, I think is very important here. So we look at some of the case law that exists surrounding exigency. And we know there has been a bit. I believe the Campbell decision, which, if I'm not mistaken, comes from 2024, was cited by some of our, by at least one of our witnesses earlier. And I think that's a very important one. And when you look at how that decision was found, and actually I'll even share some of the facts of that case, which are quite interesting here, and speak to how law enforcement officials have to make decisions often very quickly. And a big part of their job is to use that critical judgment. In Campbell, it was actually just down the road from me the other direction, in Guelph, Ontario, where police were conducting surveillance on a drug dealer nicknamed Gammy, I believe. They had information from an informant. They obviously had enough that they wanted to investigate this. They arrested the suspect after observing what they suspected was drug trafficking activity. And during the arrest, he threw 2 cell phones onto the passenger seat, which were seized as part of the arrest. And it was a bit interesting reading the facts of this case where law enforcement actually started to communicate with someone that thought they were communicating with the drug dealer, and this went on for 2 hours. They knew that serious quantities of very dangerous drugs were in play. Heroin that was believed to contain fentanyl, which I think all of us have seen as just a scourge on our country. It's affected many of the communities we represent, and some more than other. And, police were going back and forth on this. And then what ended up happening was they arranged for the person they were texting to deliver the drugs. This was Campbell. And they were able to make the arrest because the person they were communicating with arrived at the arranged meeting location carrying the drugs, was arrested. Now, this makes its way through the courts, goes all the way up to the Supreme Court. But what the majority found was that in the circumstances, and this involved, again, a phone. Now, in this case, it was a physical phone. It wasn't an intercept like we're looking at with C-22. But, the majority held that the officers had a narrow and rapidly closing opportunity to prevent what could have been a very dangerous transaction. And there was an immediate risk to public safety. And ultimately, the majority found that obtaining judicial authorization first, having to go through that process, might have actually caused police to lose the opportunity to stop the sale and make the arrest. Now, I don't want to pretend that this was a unanimous decision. There was a dissent, and that dissent found that, you could actually get a warrant in 2 hours. And I think some members of law enforcement would probably chuckle at that because they've encountered bureaucracy. They've seen the overburdening of our justice system, which, again, is largely, I think, a response to failures in liberal policy, which are outside the scope of the sub-amendment, but I think still warranting very deliberate and diligent scrutiny. And the dissent also found that, there wasn't an identified member of the public that was in imminent danger. So there was the possibility that drugs would enter the community, but it was general enough that it couldn't be, the dissent viewed, exigent circumstances. So all of that is to say that there is dispute even among our most senior judges, and this is a very recent case. This is from 2024. But ultimately, it was exactly what we're trying to deal with now, which is acknowledging that law enforcement have to make very significant snap judgments. And, yes, it is hugely important that we have judicial scrutiny after the fact on these things. I do like that Mr. Mantle is trying to say that, hang on, we have to look at judicial oversight on this. To read the sub-amendment precisely, it's that, originally Ms. Kwan had said, named in the order within 30 days after the service of order. What Mr. Mantle has added here, or within such shorter period as is specified in the order, where the the justice or judge is satisfied that the circumstances make a shorter period necessary. So I think this is a very important point as well. And necessity is different from convenience. We're not talking about officers going through a routine motion on a long investigation and suggesting that, because they like to have the information turned back more quickly, they can short-circuit the process and expedite it. No, this is about necessity. And I know there have been other court decisions, not dealing with electronic communications, but just dealing with, in general, this idea of necessity, in which we've determined that convenience and what might make your life easier as an investigator is not itself sufficient to rise to that level of being a tremendous obligation that should force us to expedite these things. So I think all of that is why I am generally quite supportive. I'm supportive of Ms. Kwan's amendment, but I think Mr. Mantle has elevated it to a point where we were able to, again, provide a valuable improvement on what the Liberals are doing in the bill and in Clause 9 in particular. But I think it's important to note, just contrary to the rhetoric we've been hearing from the Public Safety Minister, we are trying to be very responsive and I'd say proactive. And this is a great example of that, proactive to the needs of law enforcement, recognizing the urgency that exists in some of the situations that they find themselves in. And I'll just turn to the officials on this. We know that in Clause 14, there is an exigency component of this. We know this already exists at some point in the law. How broad is that, and is it more valuable, even looking beyond this particular sub-amendment, to ensure that we have those protections spelled out, just to ensure that that any time there's a statutory time frame baked in, even if it is, as to the earlier point, trying to codify something that exists in common law, like a necessity that we don't just view that time frame as being a floor, that we always try to strive above it and move more quickly if we can.
Thank you for the question. I think I mentioned before that the provision at Clause 14, the exigent circumstances provision, can only be used during the period in which the exigent circumstances exist. So it's, in relation to a subscriber information production order, although this provision is actually being amended for that type of information, the traditional process would be to go before a judge to make sure there's judicial scrutiny. And the judge would have the discretion to order or not the production order. I'm not sure I've answered your question.
So I guess I'll be a bit more pointed with it. In the specific circumstances that we had prior to, let's take Ms. Kwan's amendment out of the picture. Are you confident that in exigent circumstances, or where exigent circumstances exist, that we would be able to expedite the mechanisms in this clause without specifying it? And if so, where would you draw that authority from? In the legislation, or in the common law if it's not in the legislation?
Well, in exigent circumstances, the bill is making clear that police can act in exigent circumstances under 47.11, so in Clause 14. So their ability to act immediately would exist with the provisions of the bill. I appreciate the sub-amendment in terms of the flexibility. There is some concern with the upper level, because there is a risk if 30 days is insufficient time, that the service provider will just object, and the process in the bill is that, or in the law currently, is that that stops the clock and no production needs to be done until the order is judicial reviewed.
So I hope the committee will indulge, because this gets to the amendment, but I think your perspective on the amendment is relevant to how we view the sub-amendment here. So you're of the view that if we specify a 30-day limit or a 30-day deadline, for lack of a better term, and some service provider, for whatever reason, it takes them 31 days, your concern is that they may say, okay, well, we've already failed to meet this deadline, therefore there's no point in following through. Is that the concern?
No, because there is a penalty for not complying with a production order. But if they find that the scope of the production is unreasonable for the time period, they have the ability to object. Like they won't be able to comply with it. And I think we've talked about this before, that there is a bit of a back and forth dialogue. The flexibility that's currently built into the law for the judge to set the time is based on that flexibility. So for instance, if the RCMP needed information from Rogers, they would talk to Rogers before they had the production order issued and come up with a time in which Rogers could provide that information. So that, depending if it's a simple production for subscriber information related to phone numbers, they might be able to do that in 2 or 3 days, and that's what they'd ask the judge for.
Now, just for, I might be, if I'm mixing up the numbers in two processes, please correct me, Mr. Wong, but there's already baked in a period to challenge these in that 30 days. Is it 10 days, correct, or is that a different section?
No, I believe you're right. It's in the amendments to, so it's at clause 10, and it is 10 business days, but that 10 business days is when they have to inform the peace officer that they will be objecting to the order and make an application to the court within that time. So that is irrespective of the delay or the time set by the judge for the production of the information.
So I realize that it's not your job to make amendments and do our work for us, but just from what you've said, is there a way to add, a 30-day or a time limit that the committee agrees to, even if we don't prescribe it to 30 days, but provide that mechanism where, in circumstances where it will take longer or a service provider thinks it will take longer, they have a way to work through that? Because my understanding is they already have that, but if we're trying to codify for clarity, I'm certainly open to other sub-amendments that might be necessary.
I think any time that you set a set period in legislation, it takes discretion away from the judge. So there may be, like, my colleagues from the RCMP were talking about tower dumps, and could be a great deal of information. It could be that they need 10 cell sites, the tower dumps for all those, for a range of phone numbers. It could be arduous work to compile all that information, and perhaps 60 days would be reasonable in that case for production. If the ceiling was set at 30 days, that would remove the discretion of the judge. What the service provider might do is, by default, object to the production order as being unreasonable, and that would stop the clock and frustrate the peace officers from being able to get their data. So there's that lack of flexibility that creates a risk.
And I apologize that I'll have to continue to stay on you, Mr. Wong, but you did mention...
Chair, point of order. I know we've been a highly efficient machine today, moving through these motions, and interested in maintaining that efficiency. Do we have a hard stop at 12 o'clock? Because if so, Mr. Lawton may want to hurry up with this line of questioning so we could actually vote on this.
Yes, we do.
Okay.
Thank you for asking, Mr. Lawton.
I'm happy to stay late. If Mr. Pawlowski is willing, I'm happy to stay late.
No, it will stop at 12.
Oh, okay. That's unfortunate, but I understand. Sorry. So on the sub amendment, you had alluded earlier, and in our previous exchange, Mr. Wong, you talked about the exigency in Clause 14. Clause 14, I'm not seeing, or perhaps you could point me to it, where those exigency authorities, for lack of a better term, would apply to the process we're looking at in Clause 9.
Again for the question. That's because in Clause 14, it's the ability of law enforcement to act in exigent circumstances, and those circumstances are using their common law ancillary powers to do regular police work and act in emergency situations. So there is no warrant or is no production order. So all we did is we spelled out that police can obtain this information in those circumstances without having to go to court.
Okay. So I think this brings us back to a discussion we had earlier in another context where we're talking about what looks like a deliberate reason to exclude information or exclude clarity from in the actual legislation. And I'll turn to our colleagues in law enforcement here. I mean, I described a situation in Strathroy, Ontario. I'm sure you're very familiar with the Aaron Driver case, and you've probably in your careers encountered numerous situations where you haven't had the timing to go through this process. Do you view specific recognition in statute of those circumstances and giving a mechanism for that as being valuable?
I'll thank you for the question through the chair. I'll give a general sort of response, and then perhaps my colleague could get more specific if you want more of an operational sort of example. But our experience with if it's legislated at 30 days will become the standard, and traditionally it removes the latitude for, as Mr. Wong mentioned. Banks and telcos are key partners in our investigations, particularly major investigations. So there is a back and forth, and depending which region of the country, there's relationships established with these businesses to say, if we need subscriber information, what the size of the telco or the company could be the difference in how quickly that happens. A larger one might say, yeah, we're going to need 3 days. Okay. We go to the judge and request in the affidavit in the court documents that we produce. We could even speak to that and say we spoke to the provider. They think they can provide this in 3 days. But there's the opposite too, where a company or bank may not feel like that's a priority for them, as Mr. Mantle had alluded to, and then the 30-day becomes the default. And if they're late, well, they're late, and essentially. That becomes the default is a late post 30-day production on some of those things. So if you're dealing with a major file with multiple targets, multiple devices, and you're trying to get through production orders, that all extrapolates into a very lengthy process. Some take you right to the 30-day point to say, yeah, we don't have it. And then you're starting again from that point. So if you add all that up on a major file, the types of crimes that cause the biggest harms, greatest harms to Canadians, and it's a major file, you're starting to, there's jurisprudence in Canada, RV Jordan, that starts to kick in with those large files. So all that to say, I can't speak to the amendment or the proposed legislation. All I can speak to is experientially that the 30 days, once legislated, becomes kind of the benchmark.
Yeah, and that's to your point, Superintendent. That's one of the things we're trying to protect against. I think we disagree because we disagree on the value potentially of having a window there. But if there is a window, I guess that's where the sub amendment kicks in. We want to make sure that window is not being treated as to your point, as a floor or as a baseline. Just when you've had to, under extreme, pressing, time-sensitive circumstances, get a warrant, what is the standard, or the standard and the quickest time frame that you can get something in those circumstances where hours matter?
I'll probably default to my colleague, as his operational recency is a lot more recent than mine.
Thank you for your question, Mr. Chair. Well, it really depends on what it is that you're actually looking for in terms of information. But if you're simply trying to confirm a name associated with an IP address or with a number or something like that, phone number, and the exigency is very imminent, there are times when a service provider may actually just provide it to you over the telephone because they know that something is going to happen within hours or minutes, and that is a very quick turnaround because they're sensitive to that.
And well, so to that point, do you find that smaller providers that don't necessarily have the bureaucracy and the processes that your large companies do you find they're generally more flexible and more amenable to dealing with this, hey, we need this now, we don't have time to go through a judge to go through that process, that voluntary turnover? Do you find that smaller companies are more flexible on that?
Well, if I speak from personal experience, I've had very positive experiences with both smaller service providers and larger ones. There are some very dedicated individuals working in both spheres, and they've been very cooperative from time to time, and they do recognize that when we are asking for something like that, that generally it's because we need it to prevent something horrible from happening.
No, it's very helpful, Sergeant. So if you have those relationships and your colleagues have those relationships, what would change fundamentally in the majority of circumstances if this bill were passed, if you already have this voluntary process that has worked and seems to work in a lot of cases?
So in terms of exigency, depending on who we're dealing with, a lot of the time it's the service provider that actually has their own criteria for exigency. So what they actually consider exigent versus what we consider exigent. Whether they've determined that the exigency has actually already passed, as Mr. Wong cited earlier, if the exigency no longer exists, then we're kind of out of luck for whatever the request may actually be. So it becomes kind of a back and forth between the peace officer, and police officers have varying degrees of experience, and depending on what level of experience that they actually have with this type of request, they may be going up against a team of lawyers at a very large service provider, and there may be an argument back and forth as to, does the exigency exist any longer? What is it? Does it meet our criteria? And if that's refused, well, then the police officer is actually no farther ahead in that situation. So in terms of what this provides, so this would be outside of the I guess the powers that we normally exercise in terms of exigency, because this is with warrant. So this is a warranted request. So the response is coming back in response to a warrant, not in response to an exigent situation.
Thank you. One thing I'll point out here, and Mr. Caputo earlier indicated, I think quite effectively, you know, it is parliamentarians' obligation, and certainly I take this as someone who values civil liberties tremendously, and you know, my respect for those is one of the reasons I ran for office. It's one of the reasons I'm sitting in this chamber. And we have to pass laws that are constitutional. And I'd actually say we have an obligation to go above and beyond. We shouldn't look at checking the box of the, you know, a government charter statement as being our floor, to use the concept we've been discussing here. We should actually be looking at, you know, ensuring that we are a country that protects in a very robust way the rights and freedoms and privacy rights of Canadians, while also ensuring law enforcement officials have the tools they need. And the reason I bring that up in the context of what we're discussing here is because I want to make sure that we're actually passing a law anytime we look at criminal justice reform that focuses on safe streets, but that doesn't create a bigger problem. And this is one of the things the Liberals pointed out a great deal in the discussions about Bill C-16. They used you know, court rulings as justification to put bad policy through at other stages in the law, and they said, oh, well, you know, the court ruled this about this, therefore we have to do this other thing, which ended up being basically a get-out-of-jail-free card on mandatory minimum sentences. But what's interesting in the context we're looking at now is that Mr. Mantle's sub-amendment, I think, is quite shrewdly worded in that he says, a judge or within such shorter period as is specified in the order where the justice or judge is satisfied that the circumstances make a shorter period necessary. My read on that is that it necessitates a record that can be used to assess Bill C-22, assess the legacy of these measures if this bill becomes law. And we actually have a very clear path where we can understand how judges are using this, how law enforcement members are seeking this, what sort of production orders they're seeking, what language they're using. And I would actually love to see, and again, I believe we have later on some amendments or clauses that deal with the reporting requirements, but I would love to see a pretty detailed accounting of how these authorities are being used, and especially when we get to part two, I regret to say how they're being abused, which is, I think, going to be quite unfortunately inevitable given what the Liberal government is trying to do in part two of this legislation. But I think having the judicial record, ensuring, and this is with no disrespect to law enforcement. I have, my brother's a police officer. I speak to law enforcement quite regularly in my community. Sorry, I don't know what was happening there, but I think it's important that we also understand that our system relies on and requires checks and balances, and it requires sometimes judicial authorization after the fact, whenever possible on these things. We would want that check and balance. We would want that safeguard beforehand. And I think what we're trying to do here is come up with that delicate balance. So, I think Ms. Kwan's amendment is quite reasonable. I want to insulate as much as possible this concern that the 30-day deadline will be treated as just a baseline. If we are going to force electronic service providers and force other companies to rebuild their systems, rebuild their apparatus, rebuild their mechanisms for responding to these, processing these requests, it is crucial that we don't just put in place a system where they take 30 days to do this. And we find that law enforcement are now slowing down something that they might have been able to do in 2 or 3 days before. That's certainly not what I believe Ms. Kwan was trying to achieve. And I certainly think that Mr. Mantle has done yeoman's work here on this. So, I think that there are a couple more points that I would like to say, and I think Mr. Pawlowski had actually wanted to hear a bit more, but he'll have to save that for the next meeting, because I realize we're coming up against the end of the clock there. But I thank you very much, Mr. Chair, and I thank the witnesses for their contributions on this.
Thank you, MP Lawton. Ms. Kwan, there are 2 minutes left, and I cannot turn to you unless others are willing to let you speak first, because there are a couple of other MPs who were first on the list. So if everyone is fine, we will let you speak for a couple of minutes, in fact, for 2 minutes in total. Thank you.
Well, thank you very much, Mr. Chair. It seems to me that everybody was nodding, so I take that as an affirmative. And I want to thank committee members for allowing me to do that. And I apologize because I wasn't here when this amendment came up. I had run into the House to deal with yet another guillotine motion on Bill C-26, and I wanted to get my comments on the record in the House with respect to that. So I'm back here now, and I think the guillotine's coming down on this one soon as well. On the premise around this amendment, though, I should first say, is actually something that the Canadian Chamber of Commerce brought to my attention. And they raised this issue with regard to the timeline for responding to production orders. And this amendment that I tabled would restore the 30 calendar day default, as is generally the case for the Criminal Code standard. Now, the amendment that has been brought forward by Mr. Mantle, I would welcome and would support. This is something that, by the way, the Chamber of Commerce themselves had also noted that they would welcome shorter periods, and they would welcome it with written judicial reasons in exigent circumstances. So, and I think that is the premise behind the amendment here, to allow for that flexibility in that way. I understand, and I heard from officials, comment to say, and what if they can't meet it in that 30 days, and then the default would be that they just won't meet the order. I would hope that that is not the case. I would hope that people would work really hard to meet the order, because the criminal standard, the criminal code standard is 30 days, and people work towards achieving that. And so I think in this instance, bringing that forward is an important benchmark, if you will, and to put forward. Part of the problem with this bill and the approach in which is being taken is that there's not really good collaboration to talk about what needs to be done and how to bring the best bill forward. This is substantive changes to our Canadian culture that would impact privacy and civil liberties. And I get it, the importance of doing it so that we can facilitate the work for law enforcement, for CSIS, for the people who keep us safe. I get all of that. And as a target for foreign interference, I get it. Like, please, I get it. So I want to make sure we get it right, but not at this sort of breakneck speed of trying to just pushing it through. And when I say breakneck speed, I'm talking about not engaging in a process that would actually allow for fulsome engagement and input and consideration and meaningful consideration. I know that the government's gotten themselves a majority and they're going to ram it through, but I don't think that's the best way to make law. Thank you so much, Mr. Chair.
Thank you, MP Kwan. Thank you to everyone. There's not enough time to thank you in detail et avec la considération que vous méritez. On le fera peut-être jeudi lorsqu'on se verra.
I can't fully thank you. Thank you, everyone. Good night.